Reminder. And before we actually get back into Unit 7, let's first just kind of recap what we talked about last week. Unit 7 starts our agency discussion. We'll continue in Unit 7 today. I'm not sure that we'll get through it, which means we'll have more to wrap up on next week when we meet. So Unit 7 is pretty deep. It's pretty in depth. And guys, please remember what we say. You're not going to leave this call today as an agency expert. So you guys need to revisit it. You need to reread it, re-listen to it, rewatch it, retake those quizzes. Keep going back through it. I promise you, the more times you expose yourself to this material, the better it's going to stick here. So as we go through today, I got a couple other resources for you guys that I'm going to share with you, so you can look at those if you haven't yet. But let's first just recap where we were last week. If you will, please turn to page 137 in your book. And one of the first things we did when we talked about agencies, we had to define some words. Basic understanding is to know what the words mean. So remember, we talked about you guys making your own flashcards. And I am a fan of you guys making your own flashcards, but I'm telling you, if you try to make a flashcard for every single vocabulary word, you're going to have stacks of flashcards 3 times you, right? So you're going to be able to fill a whole room. So your flashcards need to be with purpose. What terms are you struggling with? What concepts are you just not getting? Those are the ones that are good candidates for flashcards. If you look at the definition of agency and you feel comfortable knowing that it's a fiduciary relationship, then you don't need to make a flashcard out of it. Everybody with me? So kind of use those flashcards to cater to you in the areas that you feel that you need to review over and over and over again. So we defined some words on 137, and then we started defining that relationship between the client and the customer. You become my client because you hire me. How you hire me is by entering into an agency agreement with me. So when I first meet a consumer, by default, they're all customers. Now we're gonna maybe get to today, at least start talking about it. There's something out there called agency disclosure. So when I first meet a consumer, I have to disclose my agency status. I have to tell them what role I'm playing in this transaction. That's only fair. It's only fair to let the consumer know. That consumer they're my customer. That's that third party that hasn't hired me. Once they hire me, then they become my client. And again, how do you hire me? How do you become my client? This is why we have our agency agreements that we will look at when we get into Unit 8 next week. So agency agreements is what we use. It's our employment contract. It's what we use for the customer to hire us and become our client. We talked about the different duties that we owe our customer and our client. Y'all remember our airplane? Does the airplane help give us a visual? So your clients get first class treatment, right? Your customers are back in coach. We're all still on the plane. You're flying the plane as the agent, the broker in the transaction. We're all still flying the plane, on the plane. We're all still getting from point A to point B. But the difference is the level of service that you receive in between. Isn't first class get more? Don't they get better stuff and more and better stuff than back in coach? So same thing with the client. In real estate, the client gets what we refer to as old car. And we spent a good amount of time going through old car, talking about obedience and loyalty disclosure on page 139. Over on 140, there's our confidentiality accounting, and then our reasonable skill, care, and diligence. So the client gets old car. Again, how do you get old car? How do you get to ride first class in my plane? You hire me by entering into an agency agreement with me. Those that don't enter into an agency agreement with me get coach. They are our customers. Am I allowed to lie to my customers? Can I lie to them? No. Can I be deceitful or dishonest? No, no, I still have rules on how I work with those customers. And on page 141, I owe my customers, all of them, honesty, fairness, and the disclosure of material facts. I owe my customers honesty, fairness, and the disclosure of material facts. You know, the image, your clients, you are you're walking hand in hand with them. You may even be taking them by the arm and assisting them through the transaction. If they need to be picked up and carried, you pick them up and carry. The customer will walk in side by side. I'm not holding their hand. I'm not going to pick them up and carry them, but I'm still going to help them get through the transaction. We're going to introduce you guys to something called sub-agency today. We're going to talk a little bit more about that, and that'll kind of help better define that role with the customer. And then over on page 142, 143, we got into our material facts discussion. We defined specifically what a material fact was. We are getting ready to talk about what's not a material fact. We'll get there in just a second. I think it's so important for your test and for the real world that you guys understand. I always have a duty to disclose material facts. Always. I don't care who you are. Are you my client or my customer? It doesn't matter. I always owe you the duty, the disclosure of material facts. We talked a little bit about the seller is protected under caveat emptor. Remember caveat emptor? Let the buyer beware. The seller doesn't have to disclose. The seller doesn't have to disclose much of anything. The real estate agent isn't under caveat emptor, you guys. We are held under license law and commission rule. License law and commission rule says we have a duty to disclose material facts. I think we can all agree at this point that this is could be a conflict between the seller and the agent. So I'm telling you, you're hiring me to list your house, and I'm telling you, you don't have to disclose. But the moment I learn that your roof leaks, despite if you want to disclose or not, I have to. Can we see the problem that sellers may have with their agents? I thought you represented me. I thought I had you my best interest. And now you're telling me you have to disclose that the roof leaks. So, you know, we set the expectations up front. We have these conversations up front with our sellers so they understand our role. Y'all, the public doesn't know our job. It's our job to know our job. So we explain our job. We explain our role to that seller so they're prepared for what we need to do. Remember, part of Old Car says, I'm obedient. I follow my principal's lawful instructions. And a lawful instruction is not asking me to keep quiet about the fact that their roof leaks. Do I have everybody? So we have these conversations early. We set these expectations up front. Then where we last left, we started talking about our prohibited conduct starting on page 143. I think the big picture of our prohibited conducts, I call these the big four. These are the big four that revolve around mishandling your material facts. And the big picture, you either lie about it or you don't say anything at all. Misrepresentation, you flat out lied about it. Maybe you knew it was a lie, maybe you didn't. But at the end of the day, it's still a lie. Or you keep your mouth shut. You didn't disclose the information that I just told you we always have a duty to disclose. Again, maybe you meant to keep your mouth shut, maybe you didn't. But at the end of the day, you guys, the fact remains that it still happened. So then we looked over on page 144 through 146. We broke down the big four with examples. I think that the examples are helpful in helping you, the scenarios, and helping you wrap your brain around the big four. And then the very last thing that we did was we introduced you guys to the License Law and Commission Rule Book that is in Learn Test Pass. Why don't we go ahead and start there? So in Learn Test Pass, under the Welcome section, you have the License Law and Commission Rule Book. and see law and rules. And my suggestion was that you guys start reading this thing a little bit at a time, but I'm not asking you to read all 128 pages. I'm asking you guys to start on page 106. 106 is the comments. 106 is the discussion of the law and the rule. Page 106 is breaking down the first 105 pages of this booklet. And within that section, starting on page 106, you will find the big four again, and you're also going to find other examples. So now we've given you examples of misrepresentation and omission, not only in Unit 7 in your book, but also in the License Law and Commission Rule. One of the last things we do in this class is the state-specific section, and starting on page 106 is the highlight of that. That's going to be the big focus on that section. So again, if you guys can start with this now and break it down, then you'll be ready to go when we talk about it near the end. So that gets us caught up. That's where we left off last week. What questions do I have about things that we've already covered? If we haven't covered it yet, we're getting ready to. What questions do we have about the first little piece, the first little section of Unit 7? Okay. All right. So picking up where we left off, we spent time talking about things that are material facts. Now let's spend some time talking about things that are not considered a material fact in the state of North Carolina. And one thing not considered a material fact, the haunted house on the block. We do not have to voluntarily disclose if a stigmatized property, was there a death or an illness or a serious conviction on the property, the haunted house. We do not have to disclose that. It's not a material fact. If I'm asked, let me rephrase that. When you are asked, because when you work with buyers, you will be asked, did somebody ever die in this house? You can choose to hide behind state law. You can choose to say that's not a material fact and I don't have to answer that. I would put that a little nicer if I were you. If you do want to answer that, you've got to be honest. So if you do choose to answer that, and guys, be very careful. You may know the current family of this home. You may know them. They may be your friends, family. And you may know that while they owned it, nobody died in this house. But before you say, no, nobody died, do you know the previous family before that, owner before that, owner before that? You guys with me? So before you say, nuh-uh, nobody ever died in this house, you got to know the history of the home. That's one reason why it's not a material fact, because we're not expected to research, go back, some homes are like 100 years old. How many years are you going to have to go back to get that information? We do not have to volunteer this information, is what we're saying. You can choose to. In some stigmatized properties, you might be better to volunteer the information, because every once in a while, a serious conviction, a serious crime happens and it hits like the national news. That's kind of hard to hide behind, isn't it? If we see about it on the news or read about it, it's safe to say your buyers and sellers in that area may know about it as well. Again, it's up to you. It's a conversation between you and your seller, how you want to address it. What I'm telling you is you don't have to volunteer the information. However, if you're ever asked, you can't lie. You can never lie. Is I don't know an honest answer? If you don't know, genuinely don't know, that's a pretty honest answer, right? I didn't lie. There is one exception to this rule. Good morning. There is one exception to this rule. The exception to the rule is if anybody has ever lived in the home that had AIDS or HIV. AIDS and HIV are a protected class under handicap disability under federal fair housing. They are a protected class. Remember, we got a whole unit dedicated to fair housing. So we'll see that again. We'll talk about this again and more specific about handicap disability status. If you are ever asked, did somebody ever live in this home that had AIDS? Your answer is always, federal fair housing prohibits me from answering that. Federal fair housing prohibits me from answering that. I don't care if you know or not. Your answer is always, federal fair housing prohibits me from answering that. Another thing that's not considered a material fact in North Carolina is the presence of nearby sex offenders, convicted sex offenders. Again, we don't have to volunteer the information. If we're asked, we can't lie, but we don't have to volunteer the information. When it comes to this one, I'm a huge fan of being the source of the source. So when your buyers or tenants ask you, are there any sex offenders that live nearby? Send them to the North Carolina Sex Offender Registry website. Let them do their research. And let's keep a couple of things in mind as well. First off, so everybody note this word, convicted. Only convicted sex offenders are going to be on the sex offender registry. Unfortunately, not all sex offenders have been caught yet. So if you're saying, no, there's no sex offenders live nearby, that's a pretty bold statement unless you go and ask everybody in the neighborhood. Everybody with me? So what the registry is going to do is tell us convicted sex offenders. The other thing we need to be aware of, there's a national law, it's called Megan's Law. Megan's Law requires convicted sex offenders to register their address. They have to register their address. That's how we get the information on the sex offender registry. But guys, there may be or there may not be a convicted sex offender that lives nearby today, but that doesn't mean one can't move in tomorrow. So again, just caution your buyers. It's a self of security. I get what they're trying to protect their children, absolutely. But there's still that duty. We need to know where our kids are and who they're with, because there is no guarantee that they have been caught yet, or one just doesn't move in. I actually took a CE class. It's been a couple years now. We were still face-to-face. And a CE class and material facts came up in our continuing education, as they usually do. And particularly this conversation came up. And one of the agents in the class said, I recently listed a house that the guy that lived across the street was a convicted sex offender. And the sellers shared that with him. And they said, what do we do about that? He said, well, real estate commission says we don't have to disclose that. We don't. We can choose if we want to disclose that or not. So he had a conversation with the sellers. And at the end of the day, the sellers agreed to disclose. The sellers wanted to volunteer that information because they said if we were buying, we would want to know. I thought that was pretty admirable of the sellers to want to disclose that information. What we need to understand is they don't have to. You don't have to volunteer that information. But once again, if you're asked, you can't lie. Okay. So not considered a material fact, things that we don't have to disclose, volunteer. We can if we want to, but we don't have to. Any questions on those? I usually get asked a lot, are you ever asked if there's a convicted sex offender? Sure. Several buyers have asked me before. Have I been asked about the haunted house? Did somebody die? Sure. I've never been asked if anybody had AIDS or HIV, but guys, if you are, you need to know how to answer that question. Obviously, it's a concern enough for fair housing that they make sure that we know up front. So if you are ever asked, you know how to respond. Is this the same thing as death? Death could be a stigmatized property, and it's not a material fact. You don't have to work with many buyers before you're asked, did anybody ever die in this house? That'll come up early in your career. Yes, ma'am.
Are all deaths related to disabilities protected as well, or is it just the AIDS?
It's just the AIDS and HIV. And you know, I don't know the answer why that those particular illnesses are pulled out. I do not know the answer to that, but yeah, the only thing protected, the only exception to this rule is those with AIDS or HIV.
Huh, okay, cool.
You guys remember when was it? 6-7 years ago, the Pazoo's house in Clemens? It was bad. It was bad. It made national news, y'all. I'll let you look it up. Please don't do now. Wait, make yourself a note, look it up after class. And we made national news. Clemens, North Carolina made national news. That house has since been burned down. I don't know, or torn down. I don't know if anything is rebuilt yet or not. But when that hit national news, what do y'all think happened to the values of the homes on that street? Oh, they tanked. Nobody wanted to live. It was hard. And as a matter of fact, we were still in person, and I had a pre-licensing student that was trying to sell the house across the street. And her buyers found out what happened and they terminated. They chose to walk because of the stigma, because of what that draw. Everybody has different feelings on this, right? Everybody has different approaches to what is a stigmatized property and what's not. So what we can do is just let your buyers, you know, you can go to Google and put an address in and see if there's anything that made the news. But let your buyers kind of do some research. We're encouraging them to study the home anyway, you know, drive by it at different times of the day. Like, what does it look like when the sun's coming up in the morning? What does it look like when the sun goes down? You know, there's street lights, right? Drive by at different times of the day just to see what they're getting ready to get into. But also send them to Google. They can do a Google search and learn about the property as well. And they need to make that decision if a stigmatized property is of concern to them or not. By the way, she did get the house back under contract. She chose to disclose it the second time, and then the next buyer closed. It didn't bother them, but it did the first one, so they had that right to terminate. Other questions or comments, things that are not a material fact? So let's kind of wrap up material facts, talk about what this means to us. As I've been saying, please hear me. We always have a duty to disclose material facts. It doesn't matter who I'm talking to. Am I talking to a client? Am I talking to a customer? Even if my client says, shh, don't say anything, that doesn't negate my duty to disclose those material facts. Disclaimers don't protect us. So you're not going to be able to put something in your email that says, I'm not liable for you discovering material facts, right? You can't put anything in your email signature or something like that to try to protect your liability. Disclaimers are not acceptable. And as we've been saying, you guys always need to be on the lookout for red flags. And if your little red flag goes up, that's going to prompt you to ask some questions, investigate further, try to get to that material fact. Good morning. Over on page 147, there's some additional duties. We're going to go through these pretty quickly. We're going to spend more time with these. We see these in license law and commission rule. So if you started looking at page 106, you're going to see these. We're just going to go through them pretty quickly now, though, so we can get on to some other stuff, knowing that we're going to come back. So on page 147, we talk about some additional duties, some additional things that I owe consumers in the transaction. And I hope a lot of these make sense. For example, I can't make false promises. If you're going to tell somebody you're going to do it, do it. Particularly, the commission says any promise that's likely to influence, persuade, or induce. And that does include communicating with other agents and your advertising. I remember last week we talked about puffing. Make sure that your opinion doesn't cross the line into a flat out misrepresentation. So we have a duty to avoid making false promises. We have a duty to avoid a conflict of interest. We're going to talk about undisclosed dual agency in just a bit. I'm getting to dual agency. So hang on to that for just a minute. Undisclosed dual agency is considered a conflict of interest, a duty that we have to avoid. We have to avoid self-dealing. If it's in my best interest, it's probably not in my client's best interest. So we need to make sure that we avoid that conflict of interest. Remember, I hold my clients, what my client wants, my client wishes above all others. In some cases, maybe even my own. And then representing another broker without consent. That kind of ties back into undisclosed dual agency that we'll talk about. That's the key to dual agencies. It has to be disclosed to both parties. If I'm representing, I think another good example of this, once you guys drop your provisional status, you get your license and your provisional broker. Once you drop your provisional status, you're a full broker. And as a full broker, you can be duly affiliated. As a full broker, you can have your license with 2 different real estate firms. And that's okay, as long as you have permission of both brokers. So for example, my license is currently in Winston-Salem, an office of firm in Winston-Salem. My retirement plan is a condo at the beach. So it might be that I choose when I have the condo at the beach to be duly affiliated, have my license in Winston and have my license down at the beach. And that's okay for me to do, as long as I have permission from both brokers, as long as I have consent. We have a duty to properly account for any monies, particularly those held in trust. We're going to talk about the trust account, also known as the escrow account. That's in that license law and commission rule section. So we'll get to that with our state section at the end. Bottom line, you guys, anytime you have somebody's money in your hand, that's your responsibility. So accounting for other people's monies, making sure that their money is getting them to where they need to go, where it needs to go, is an additional duty that I owe my client customer. We have a duty to act competently. When in doubt, find out. If you're filling in an offer to purchase and contract, you're filling in the blanks on behalf of your buyer, and you don't know what goes in a blank, find out. Once you get your license, you have the tools and the resources. Don't just haphazardly complete a legally binding contract on behalf of your buyer or seller. We have to avoid improper conduct. We always have to conduct ourselves properly. They really do take the fun out of it, don't they? Act competently, avoid improper conduct. A lot of this stuff makes sense. I hope so. I hope so. So let's see, you're working with 2 separate firms with permission from both BICs. Does it matter whether you're doing residential, commercial? You can do whichever, correct? As long as I have permission from both, absolutely. Yep. So my firm here in Winston-Salem, we only do residential. And if I ever want to dabble in commercial, I might be able to affiliate with a firm that does commercial. And that's okay for me to do, as long as I have permission of both of my BICs, as long as I have permission from both of my firms. Yep. We have a duty to deliver instruments to our clients and customers. Now, first off, let's talk about what the heck an instrument is. An instrument is just any document related to this transaction. So it starts at the beginning of our relationship with our agency agreement and disclosure. We move on. Hopefully we get it under contract. So now we have contract paperwork. And then hopefully we take it a step further and we're able to close it. So now we have closing paperwork. So when we refer to an instrument, we're just referring to all those documents that relate to this transaction: agency paperwork, contract paperwork, closing paperwork, and anything that may fall in between. And what this commission rule is addressing, The consumer has a right to receive a copy of the documents that they signed. Doesn't that make sense? If you were signing an agency agreement or a sales contract, wouldn't you want a copy of it? So that's why we have this duty to deliver it within 3 days from execution. By execution, we're saying for when it's been signed, from when all parties have signed it. So you get that agency agreement signed, you send your buyer an email, it says, here's our signed agency agreement. I look forward to working with you. You have delivered that instrument. Get them under contract, send it to them. Anytime something's been signed, we have 3 days to send it to them. Guys, it's as simple as sending an email with a PDF attachment. And please note, my job is to deliver it. I don't know what they're going to do with it when they get it. Are they going to delete it? Are they going to print it out? That's not really on me. My job is to get it to them. So let me ask you guys, and you can do your head one way or another. If you deliver an instrument and you choose to deliver it via email with a PDF attachment, are you going to document that sent email? Shake your head, yes or no. Are you going to document that sent email? And you guys do my heart good because I'm seeing head shake yes. Because what do we document? Everything. So you send the email, here's our agency agreement. I look forward to working with you. You go into your sent file, you label it, whatever you have the transaction, 123 Main Street. And then you have documentation that you sent it. Again, what they do with it, not on me. My job is to deliver it. The exception to this rule, there's exceptions to rules. The exception to this rule, we have a duty to deliver all offers to our sellers immediately, but in no event later than 3 days. Delivery of instrument says we have up to 3 days to deliver it, with the exception of an offer to our seller. Then we have a duty to deliver it immediately, but in no event later than 3 days. By the way, in real estate, a day is a day is a day. Sunday counts, Christmas counts. A day is a day. We're talking calendar days here. We also have a duty to disclose commissions, referral fees, kickbacks. You know, the general rule of thumb here says we spell out in our agency agreements, and we'll look at this when we get to Unit 8, and we'll look at where we actually say this is how much I expect to get paid. So we have to have a conversation about our commission with the consumer before they hire us, when they enter into that agency agreement with us. And let's say, for example, you and your buyer agree that you should get paid X amount to help them buy this house. Your firm will have a policy that tells you what that X amount is. So your buyer says, yeah, I agree, I'll sign. So we've entered into an agency agreement. We've entered into an employment contract where the buyer agrees to pay you X amount. Then let's say, for example, they're interested in a new construction property. Some builders may offer a buyer's agent's bonus. Some builders may say, I'll give you $500 if you bring me a buyer. What the commission says is we have to disclose that $500 to our buyer. We've already agreed we're going to get paid X amount. So if we're going to make more than what we've agreed to, we have to disclose. We've got to let our consumer know, because now you're getting the agreed upon amount plus $500. The other thing I want to point out on page 147, just because I get asked this a lot, I hope you guys are paying attention to the in practice and for examples, but the in practice on page 147, your firm very well may have errors and omissions insurance, E&O insurance. Think of this as like the doctor's medical malpractice. So if you unintentionally mess up, you could be covered under their E&O. If you purposely do it, if you purposely go out and do wrong, they probably won't cover you. Again, your firm policy, you will talk about E&O insurance. So gee, Julie, what's the big deal? Well, breaching our agency duties is a big deal. First and foremost, you're facing disciplinary action by the North Carolina Real Estate Commission. Guys, the Real Estate Commission isn't going to fine you. They can't, they don't have that power. The Real Estate Commission is a licensing body, which means they regulate your license. So if you face disciplinary action because you violated one of your agency duties and you face disciplinary action, they could suspend your license, they could revoke your license, they could slap you on the wrist and say, don't do it again. But they have the power to reprimand your license. The court is who has the power to sue you. So if the injured party hires an attorney and you're looking at civil action or criminal prosecution, now you could be fined. Maybe you could be facing jail time, who knows? There could also be civil liability. We're going to talk about the principal's duties in just a second, what they owe me. So there could also be civil liability for my misinformation, my misconduct. Again, we'll talk more about what the principal, what the client owes me in just a second. So let's talk a little bit more about this disciplinary action, just to kind of brief what happens. I don't want to scare you guys, but we need to be aware of what happens. If a consumer, well, let me back up for a second. Who can remember what the Real Estate Commission's main purpose is? What is their main purpose? Is it to license you? Is it to help you make lots and lots of money? No. Their main purpose is to protect the public that you are working with. Everybody with me so far? So if you harm their public, that's where you could face disciplinary action. If the consumer files a complaint, they can do so right on the commission's website. If the consumer files a complaint, the commission will launch an investigation and they will send the agent and possibly the broker in charge, it depends, what's known as a letter of inquiry. A letter of inquiry is not a disciplinary action. The letter of inquiry is the real estate agent's opportunity to state their side of the story. The Real Estate Commission gets that there's 2, sometimes even 3 sides to the story. And they understand that sometimes their public gets upset and has an open forum and goes on the website and starts pounding out a complaint. It's got to have merit. It's got to have validity before they can take action. So they do give you an opportunity to state your side of the story. How you respond to that letter of inquiry is with your documentation. You're not going to be able to call the Real Estate Commission and say, I didn't do it. You respond with your email correspondence, your text communications, your agency agreements, all of your paperwork, all of your documentation. That's your response. See why I want you guys to document everything? Because should you ever get that letter of inquiry, that is your proof. Maybe you did it, maybe you didn't. I don't know. But that is your proof. So you respond to the letter of inquiry, and then from there, the commission will make a decision. If they need more information, they'll reach back out to you, making that decision. Occasionally, brokers have had to stand in front of the commissioners. I think they're still on Zoom. I don't think they're back in person yet, but I think they are still on Zoom. So you may be called to stand in front of the commissioners to state your case. At any point from the time you receive a letter of inquiry, we are always welcome to get our own representation. So if you get that letter of inquiry, you're welcome to hire an attorney. If you get called to meet in front of the commissioners, you're welcome to have an attorney come with you. At the end of the investigation, if they find you guilty, they have the power to suspend your license, revoke your license. You have the option of surrendering your license if you want. Every complaint is filed on a case-by-case basis. They look at all the facts of that transaction. So I tell you that to say there's not an across the board. Because I get questioned, well, if I do this, what's going to happen to me? First off, I don't know. I'm not the real estate commission. I can't answer that. But they look at everything case by case. There isn't a flat answer. So everything is looked at case by case. Every single transaction is different. It all has different facts, different information, and the commission will do everything to investigate to make sure that their public's protected. Questions or comments on that? Once you get your license suspended, can you get it back? So they may suspend it for 2 months, 6 months, 2 years, right? So if it's a suspension, it's a period of time. Can you get it back at the end of your suspension? Yeah, they may require you to do some extra education, take some extra CE classes, that kind of thing. So if they do require you to do additional education, you're going to want to do that during that time. If they revoke it, you're not getting it back. If they revoke it, they're taking it back. If you surrender it, you're not getting it back. They could just slap you on the wrist and say, take an extra continuing education class and don't do it again, right? It just depends. And bottom line, it comes down to how badly did you harm their public? That's what they're looking at. I'll tell you guys the worst part about disciplinary action from the Real Estate Commission. The Real Estate Commission sends all licensees an e-bulletin once a month, an email e-bulletin once a month. And there's a tab in that e-bulletin every month with disciplinary actions. And they name you, name, city, firm, what you did, and what happened to your license. Yep. Additionally, and I just found this out, additionally, they'll also print it in the local paper. So if you don't get the e-bulletin, that's been my experience. That's what keeps us out of, right? Conduct your business. Always ask yourself, is this going to get me in the e-bulletin? Because if it could get you in the e-bulletin, don't do it. How do you know if it's going to get you in the e-bulletin or not? License, law, and commission rule. That's why I always feel like my job is twofold. Of course, the big piece of my job is to give you the information you need to pass this test. I'm not here to teach you guys how to be good agents or bad agents for that matter. I'm not here to do that. My job is to get you the information you need to know to pass these exams. The second piece of my job is to help keep you out of trouble once you do get your license. And how do we keep you out of trouble once you have your license? That's the license, law, and commission rule. That's the focus of this class, and that's what we're working on. So stop and ask yourself, is this going to get me in the e-bulletin? And if so, you may want to rethink your action. We live our lives to stay out of that e-bulletin. Okay. Our agency agreements are a bilateral contract. Bilateral. And we'll meet this word in Unit 9. Bilateral. In contract world, lateral means side. And a bilateral contract says both sides have to perform. Both parties have duties and obligations to each other. It's a two-way street. Our agency agreements are a bilateral contract, which means not only do I have duties and responsibilities to my principal, but my principal has duties and responsibilities to me. My principal has a duty to me to act in good faith at all times. They can't hinder my efforts to do my job. If you hire me to list and market and sell your house, you can't hinder my efforts to do that. If you hire me to help you buy a house, you can't hinder my efforts. Let's say, for example, you take on a listing and the seller never allows a showing. They decline every single showing request that comes in. It's kind of hard for me to sell a house if I can't get a buyer in the front door, right? So that may be a violation of my principal's duties to me. Now, guys, let's be fair. If your seller calls you on Tuesday morning and says the whole house has come down with COVID, we need to stop showings for a week, is that reasonable? sure, the buyers probably don't want to go in there anyway. So I'm not talking about, illness or, maybe we have a new baby. The sellers say they have a new baby and nap time is from 1 to 3. Can I say no showings from 1 to 3 so don't wake the baby up? Sure. It's still their home. For the most part, they're still living there and trying to operate. So we can be reasonable, but they got to let somebody in the front door at some point so they can view the home and make a decision. They have this duty to act in good faith. The other duty that the principal owes me is to pay me. My listing agreement and my buyer's agency agreement, property management agreement, all of our agency agreements discuss how much I'm going to get paid and when. When have I earned my commission? We've got to discuss commission. Please remember, if you haven't written this down yet, please do so, because I do think this tends to be a problem topic. Agency agreements are employment contracts. Agency agreements are employment contracts. We are being hired to do a job, and it's a very specific job. The listing agreement, I'm being hired to list, market, advertise, and sell the seller's home. The buyer's agency agreement, I'm being hired to help them locate and purchase a suitable property. Questions on what the principal owes me, what the client owes me? It's pretty simple. Don't prevent me from doing my job and pay me when I do. That's a great question that comes in. We're actually getting there, but I will go ahead and address it. The question comes in, the agent earns a commission whether or not the seller decides to sell the home. Yes, technically, I have earned my commission when I connect buyer and seller. So if I have a full price offer, that's everything the seller ever wanted, I've earned my commission. I can't make the seller accept it. The seller doesn't have to accept anything. I've earned my commission when I've connected the two. I don't get paid until it closes. We'll talk more about your commission, how we can get you paid. That's Unit 8 when we get into our agency agreements. So I've earned my commission when I bring my seller an acceptable offer. Seller doesn't have to accept anything ever. Be it cash, full price offer, closing in a week and a half, and the seller doesn't have to accept it. They're under no obligation to accept anything ever. The principal also has duties to third parties. So for example, sellers can't lie to buyers, buyers can't lie to sellers. Your principal has a duty to the other party in the transaction. Bottom line, they can't lie. If it is found out that they lied, the injured party can hire an attorney and sue. Are they going to get anywhere? I don't know. They better have proof. If your buyer thinks that they were misinformed, that they were lied to by the seller, they better have proof. North Carolina favors the sellers. Have we figured that out? Sellers don't have to disclose, they don't have to fix, they don't have to do anything. What they can't do is lie. Nobody has a reason to lie. If your principal violates their duties, again, they can be sued. They could be subject to civil or criminal. And if it was found out that the agent's misconduct was by the principal, then they may be responsible for our civil lawsuit and criminal prosecutions as well. Again, the commission and the courts are going to ask us, could you have found out? Could you have reasonably found out otherwise? One more thing we're going to mention real quick before we take our break. There's something called the Unfair Deceptive Trade Practices Act. This is what protects the consumer from fraudulent information. Again, the seller doesn't have to disclose. The seller is protected under caveat emptor. But that's not a golden ticket for them to lie. They don't have to volunteer, but they cannot lie. We have a couple seller disclosures that we will look at in Unit 8. And one thing of note that I always think is really interesting on the seller disclosures, they have the option of saying no representation. It's going to ask the seller, for example, the condition of the roof. Is the roof in good condition? And the seller can say yes, no, or no representation. So they have a choice. Either you disclose or you don't. The seller can hide under caveat emptor. We cannot as a licensee. Questions? Except, can we take a break? Okay, so let's take 10. We come back, we're going to keep going in Unit 7. Welcome back. we back? All right, cameras are on. So I am taking attendance. And we are continuing on in Unit 7. And I want you guys to look at the top of page 149. And I want you to start it, highlight it, draw some arrows to it. I have taken attendance, so if you're just coming back, please tell me in the chat so I can count you here for the hour. The classification of agency relationships at the top of page 149 tends to be a problem topic all day long. Just dog ear it, highlight it, make flashcards out of it. Thank you. Okay. So there's different classifications of agency relationship. And what this tells us is the authority, the power that we have when we're working with the consumer. There's different levels of power. And that's what this classification of agency is telling us. And thank you guys for telling me that you're back from break. The first level of power is a universal agent. The universal agent is the agent that has full power to act on behalf of a person. You can make their decisions for them, medical, financial, whatever. You are a universal agent, which means you can do anything that that person can do. You can do it on their behalf. Let's call the universal agent our purple unicorn. How many times do you see a purple unicorn out in the wild? I never have. Do you know how many times you're going to see a universal agent, an agency? About as often as you see a purple unicorn. You guys, let's think this through. Remember, the relationship, the agency relationship is between the client and the firm, not the individual broker. My question to you, are you going to give full power of attorney to, for example, Coldwell Banker? Are you going to let the firm handle your affairs? Are you going to let the firm make decisions for you? Are you going to let Coldwell Banker have full power over you? And I hope you're shaking your head no. Because the relationship is between the firm and the client, the universal agent, the full power isn't going to happen. Then we have a general agent, which has some power. We have some ability to act on a person's behalf. The general agent has limited decision-making authority. There are two examples of the general agent that we see in our agency relationships. The first example is the agent acting as a property manager. The owner of a property has hired you to manage their property. Now we're going to talk about the property manager. That's Unit 12. So we'll talk more about then. But let's think this through. If you hire me to manage your property and I have no power, I can't make decisions, I can't bind you, I can't do anything. As your property manager, I'm calling you 10 times a day. Furnace filter needs change. Can I go do it? Hot water just broke. Can I repair it? Right? Tenant moved out. Can I find a new one? As your property manager, if I have to call you for every single little thing, at one point, aren't you going to start and wonder why you paying me? Why'd you hire me if I have to call you all the time? So the property manager has some power. What power does the property manager have? We need to spell that out in our property management agreement. The property management agreement is the agency agreement. It's the employment contract that the owner uses to hire us. And within that employment contract, what we can do, what decisions we can make have got to be spelled out. So it's not like you just have some power to do whatever you want. your power is still limited, and it's spelled out in the agency agreement. So maybe, for example, the owner and the property manager decide that the property manager is free to make any repairs up to $500. That means the property manager, if something breaks and it's $499, the property manager doesn't have to bother the owner with that. Now, if something breaks and it's $501, now the property manager has to contact the owner. I have some power, but not full power. Again, we'll talk about the property manager. Unit 12 is dedicated to the property manager. The other example of the general agent is your relationship with your firm. As we're going to learn at the end of this unit, your firm is not hiring you. You're not an employee of your firm. You're going to come on as an independent contractor. You're going to affiliate with your firm. We'll talk a little bit more about that. The relationship that the agent has with the firm is that of a general agent. We have some power to act on behalf of our firm. For example, we're all good, right? Our agency agreements between the client and the firm. Everybody good with me there? The client hires the firm allows me to work with their buyer or seller. My general agent relationship with the firm, I'm allowed to sign the agency agreement on behalf of my firm. So when I'm entering my firm into an agency agreement, I sign my name, Julie A. Campbell. The reason I'm allowed to do that is because I'm a general agent of my firm. I have some power. You may, and all firms are different, you may, for example, have the power to negotiate your commission. The firm may give you some wiggle room because the seller will look at you and say, is your commission negotiable? And how you respond to that, how you answer, that's up to your firm's policy. But as a general agent, you may have some power, for example, to negotiate that commission. So 2 examples of the general agent with some power. The property manager with the owner and the agent's relationship with their firm. Again, what power that is has to be spelled out. So the universal has full power. The general has some power. What do you think the special agent has? No power. The special agent has no power. This is the sales agent. This is our relationship as a sales, residential or commercial. This is the relationship between the sales agent and the buyer or seller. I cannot speak for my buyer or seller. I only speak on their behalf. I'm not making decisions for them. I advise, I can offer my opinion, I can provide them factual information to help them make the decision, but I am not making the decision for them. I am not speaking for them. I'm only speaking on their behalf, which means they're saying, Julie, I want you to respond to this offer as such. And my response is under their instructions. So the universal is full power. General has some power. Special has no power. And I think with general and special, if we can know the relationships that fall under that. For example, special agent is a sales agent. General agent is the property manager. As we are learning and understanding our duties under sales and property management, what questions do I have about these? Universal, general, and special. Okay. Bottom page 149, we define some more things, defining some more words. Brokerage is the business of bringing buyers and sellers together in a marketplace. We are connecting buyers and sellers. We're helping our sellers find buyers. We're helping our buyers find property to purchase. So brokerage is just the business of bringing buyers and sellers together, tenant and landlord. You could brokerage that deal. The broker is the individual agent. North Carolina is a broker state, which means we're all brokers. Some states have sales associates. We don't have sales associates in North Carolina. We are all brokers. So the broker is the individual working with sellers and or buyers. Commission is what we get paid when it closes. We earn our commission. We've done our job when we connect the two, but we don't typically get paid until it closes. We'll talk a little bit more about that. Our commission is usually, again, every firm is different. They all have different policies, but our commission is usually a percentage of the sales price. Commission is usually, you may in property management, maybe a percentage of rent collected. It may be a flat fee. You can negotiate flat fees in sales as well. That's why I stress the word usually a percentage of the sales price. When we get into Unit 8, we're going to learn that there's actually a law that says that firms set their own commission. So they charge what they want to charge. It's up to their policy. Every single firm is different. So let me ask you, does that mean every single firm can charge something different? Do they all have that power? Yeah, some charge more, some charge less. When you guys start talking to firms, and I'll talk a little bit more about that in just a minute. When you guys start talking to firms, you're going to want to ask, what's the commission split? What's your compensation policy? Because I think it's important that you guys know how you're going to get paid if you affiliate with this firm. If you want my honest opinion, I know you didn't ask for it, but here it is anyway. When you are interviewing, when you are talking to different firms and trying to figure out which one you want to affiliate with, if I were you guys just coming out of pre-licensing school, before I ask about how much am I going to get paid, I would be asking, what kind of training do you offer? What kind of training program do you have for new agents? If you guys can get the proper training once you get your license, the money will follow. You're positioning yourself for a long-term career. Again, that's just my opinion. Y'all ask what you want to ask. But before you worried about how much I'm getting paid, you got to learn the job first if you want to be successful, if you want a long-term career. I'm talking more about commission. The cooperating broker is the broker of the transaction with a different firm. So let's say, for example, firm ABC and agent Sally are representing the buyer. And then up here you have firm XYZ, agent Bob, and they're working for the buyer. Bob and Sally are cooperating brokers. Bob and Sally come from two different firms. Yes, Sally's with ABC, Bob's with XYZ. Bob and Sally are with two different firms. They are cooperating. Even though they're with two different firms, sometimes competing firms, they're coming together in the transaction for the purpose of getting buyer and seller to closing, of getting buyer to buy the seller's home. We're cooperating together. We're working together. Compare a cooperating broker to something referred to as an in-house transaction. An in-house transaction says Sally's with ABC and she works with the buyer. Ned is also with ABC and he's working, oh, I did that wrong, didn't I? Seller. I see now. Sorry about that. This should not say buyer. That would make more sense if this said seller. Sorry about that. So if Ned and, dang it, Julie. So if Ned and Susie, there we go. You see Sally. Okay, so if Ned and Sally are both with the same firm, Sally's working with the seller and Ned's working with the buyer, it's an in-house transaction because it's one firm. Sorry about that, you guys. Are we good now? So cooperating is two different firms, agents from different firms coming together. In-house, we're all from the same firm. Yes, ma'am. I see a hand.
So I see you typing. Are we supposed to just see you, or do you have like another screen that where you wanted to show us?
You don't see my PowerPoint?
Mm-mm.
So look at your view. Somewhere on your Zoom toolbar or somewhere near the top, you should have a view.
Mm-hmm.
And you can, I don't know what it's set to, but look at your different settings there. I should be very small in the top corner. I'm not the
No,
focus.
yeah, I see you as that. So do I like it had been showing that for,
Gallery or speaker, do you have different options here?
it just says exit full screen, hide video panel, and side by side mode.
Try playing around with those. It's something in your view.
Okay, sorry for interrupting.
No, this is important. Has
Go
this
to
been the
side
way the
by
whole time?
side mode.
So you
Click
can,
on your
yeah, I
side
mean,
by side mode.
side by side mode would work.
Okay, yes. Mm-hmm. Thank you. Sorry.
Yep. Questions on our definitions so far? Again, just defining words so we can have conversations. Okay. The North Carolina Real Estate Commission gives us license requirement. There are certain activities that are required to have a license. And what those activities say, what the commission says, if you're involved in the transfer of real property for others for compensation, in this state, a real estate license is required. And when we talk about the transfer of real property, we can remember those activities that are involved in the transfer of real property by remembering LL Beans. So when I'm engaged in list, lease, buy, exchange, auction, negotiate, or sells real property for others for compensation, we have got to have a real estate license. What I'm telling you guys, think of your commission or your license, excuse me, your license as a funnel. We've got to have all three of these activities to have a license. So what if, for example, what if you were not going to sell a house for others? What if you were going to sell it for yourself? You're no longer doing it for others. You're doing it for yourself. Is a license required? Do you have to have a license? No, because we need all three pieces. The transfer of real property for others for compensation. For sale by owners aren't represented. For sale by owners didn't hire anybody. Some of them may have a license, some of them don't. You guys seeing for sale by owner signs out there a lot? I'm sure I got you guys looking for all sorts of things now. Zoning, FSBOs, they're out there. You guys starting to notice more yard signs as you're driving around and looking for them now? You're seeing it? Gosh, as this market picks up, we're going to see more and more. Very exciting. So the commission's requirement for a license is all three of these activities. I understand that this says compensation, and then we have a little picture of money right here. Actually, with compensation, I want you guys to just think of consideration, something of value. I think more often than not, we tend to think we're going to get paid, but we can't receive, somebody that's not licensed can't receive any form of consideration without having a license. If you were, let's say your parents own a duplex and they're renting out one of the units and they're letting you live there, an unlicensed person live there rent-free to manage the property. Is free rent something of consideration? Heck yeah, it is. Is free gas well, if you do this for me, I'll give you a gas card. You guys see, so we're looking for something of value. If you're receiving anything of value, transfer real property for others for compensation, then you need a license. So all three are required. LL Beans helps us remember those activities of transferring real property. Then we start talking about how we create agency relationships. So we've already talked about this. Our agency agreements create the agency relationship between the client and the firm. The client hires the firm. When we get into Unit 8, we're going to talk about our listing agreement. We're going to talk about our buyer agency agreement. When we get into Unit 12, we're talking about our property management agreement. Those are agency relationships. Those are agency agreements that create the agency relationship. And we're getting more and more into talking about those. We'll look specifically at our forms next week in Unit 8. There's other types of agency relationships, though. It's not just a relationship to work with the client. This is the most common, and this is the one that we've talked about. Another type of agency relationship, again, is your relationship between whatever firm you affiliate with. You guys will go in as independent contractors. If you're an independent contractor, who do you work for? You work for you. You get to be your own boss. If you're complaining about your boss, you're complaining about yourself, aren't you? You affiliate with the firm. But there's still got to be an understanding. There's still got to be an agency relationship as your affiliation. So you could have an in-house, you will have an in-house employment contract, may also be known as an independent contractor agreement. If they expect anything when you affiliate with them, what happens if you decide to leave? So that independent contractor agreement needs to spell that out. That creates the relationship between you and your firm. We also have to have an agreement for cooperation. If I bring you a buyer, how are you going to cooperate with me? When I'm referring to cooperation, oh yeah, I mean money. If I bring you a buyer and we go to closing, how much are you going to pay me? Remember what we said last week, you guys. The seller pays the listing firm. The listing firm shares their commission with whomever brings the buyer. How that is split up, how that is handled is all covered in our listing agreement that we will look at next week. If the seller, let's say the seller is a for sale by owner, there isn't a listing agreement, right? They didn't hire anybody. They went out on their own, for sale by owner. Does the for sale by owner have to pay me if I bring a buyer? Do they have to? No, I'm always going to ask, but they're under no obligation to pay me. If I ask the FSBO, will you cooperate with me? And they say no. Now I got to go to my buyer and say, you're the only other party left in the transaction, right? And our buyer's agency agreement says, I will always ask the seller to cooperate with me first. But if they can't or won't, you're up. Y'all, these are employment contracts. We've got to discuss our commission. If you are showing property within your MLS, we'll talk about the multiple listing services a little bit more in Unit 8. For example, we got the Triad MLS. We got the Triangle MLS. We got Charlotte's is known as Canopy. I think I heard once that there are 46 different MLSs in the state. That seems pretty high to me, but as many MLSs as we have in the state, if you're showing property within your MLS, wherever you pay your dues and you're a member of, cooperation agreement will be an MLS. So in other words, when your buyer says, I want to see 123 Main Street, and you go to your MLS and pull up 123 Main Street, it'll tell you, if you bring this buyer, the listing firm is willing to pay you X amount. It'll tell you commission. It'll tell you what they're cooperating with. If it's outside of your MLS, if you want to show property in Raleigh and you're not a member of the Triangle MLS, you need to call that firm first to make sure they will cooperate with you. There's no guarantee when you go out of your MLS. So before you drive to Raleigh, I would call first and make sure that they're getting ready to, that they're going to cooperate with you. Question comes in, what if you have a property and you rent? Do you need a license? And that's a great question. You're not being a property management for others. It's property that you own. Your name is on the deed. And now you want to rent it to somebody else. Are you doing it for others? Nope, you're doing it for yourself. So is a license required? Nope. Good question. Thank you. Transfer real property for others for compensation. So anyway, the cooperation agreement most often seen in the MLS, that's information that doesn't go on to the public. That's only a member thing. So when you call me and say, this is the one I want to see, I always look at two things first. I want to know who the listing agent is, and I want to know how much you're going to pay me when I bring you this buyer. You guys all tell me, you guys come in on the first day and say, we can't do math, I can't do math. But when it comes to y'all's commission math, y'all blow my mind. Y'all can do that math. And I'm telling you, we'll do commission math at the end of Unit 8. But I'm telling you guys, when you're affiliated with your firm and you're sitting on office duty and a buyer calls with interested on 123 Main Street and you look it up, while you're still on the phone, you will have mentally calculated how much you're going to get paid when you show that home to the buyer. So y'all don't tell me you can't do math. I know you can. Some of you take it down to the penny. Y'all know how to do math. It's just math that you want to do, right? So what math do we like to do? Commission math. We will get to that at the end of Unit 8. Another way that agency relationships are created is just by the parties' actions. This is referred to as implied agency. I need you guys to differentiate between express and implied. Express means the words, the terms have been clearly stated. Maybe it's oral, maybe it's in writing. Implied says I just start acting like your agent. I don't discuss it with you. We don't have a conversation. I don't do my disclosure. I don't tell you what dual agency, nothing. I just start acting like your agent. Guess what? Implied agency in this state is not allowed. All of our agency agreements have to be express. It's got to be purposely created. The terms, here we go. The terms have been clearly laid out. Express agreement is how we create the scope of our authority. We just don't start acting like somebody's agent. So express can be in oral, can be in writing. We do have an oral buyer agency opportunity. We will talk about that in a minute. Our agency agreements handle the express in writing. That's why we have those forms that we can use. So express is clearly laid out. Implied is just demonstrated by your actions. Implied is not allowed in this state. In order for you to act like an agent, you got to explain to the consumer what that means. Everybody good with that? Y'all, they don't know. They don't know what it means to be an agent. That's our job. It's not their job to know. Their job is to sell a house or buy a house. Our job is to explain that relationship. There's also something called apparent authority. Apparent authority is a situation where the principal knows your duties, the principal knows your limitations, and they still ask you to go above and beyond anyway. That's apparent authority, and we can't do that. Let's say, for example, you have a house listed and your seller calls you and says, We are getting ready to go on a cruise. We're not going to get the Wi-Fi packet, so we're going to be out of touch for 5 days. If any offers come in within those 5 days over X amount, can you just go ahead and accept them on our behalf? What is your answer to that seller? No. Because as a special agent, what ability do you have to bind them? Zero. That's right. So apparent authority, the principal knows my limitations, but they still ask me to go above and beyond. And again, that's not allowed. If your seller has to go on a cruise for 5 days and they're going to be out of touch, they either need to leave decision-making authority to a family member that's going to be here that you can get in touch with, or maybe we just take their home off the market for 5 days while they're gone. I can't accept offers on their behalf, even with their instructions. Do I have everybody? I am just a special agent. I don't have that authority. Yes, ma'am.
Would you still send the offers, like even if they were on vacation, would you still send those through just so that you have that on your
I
record?
mean, I have a commission rule that says I have to deliver immediately, but within 3 days, right? So
Right.
yes, I would, because I still need to show that I got it to them. You know, does the buyer want to wait for them to get off the cruise boat? I don't know. I don't know. But I still have a duty to deliver that. It's a good question.
Thank you.
Question comes in about a universal agent or a general agent. Property managers tend to have a little bit more authority. But again, their scope of authority is stated out in the property management agreement. So if the property management agreement says you can do this and this, the owner can't ask you to do more than that. Universal agent is our purple unicorn, you guys. We're just not going to see it. Top of page 152, we really start talking about you guys' commission. I get that this is important. I hope it is the not most important thing to you. I'm telling you guys, if you take care of the people, the money will follow. Is it important that you get paid? Of course it is. Our loyalty is to the one that hires me. It's not necessarily to the one that pays me. Back up. How do they hire me? How does the consumer hire me? They enter into an agency agreement with me. My loyalty is to the one that enters into an employment contract for me. Let's say, remember what we said, the seller typically pays the listing firm. The listing firm shares their commission with whomever's bringing the buyer. My agency agreement is with the buyer, but the listing firm is paying me through the seller. Does that mean I owe the seller anything whatsoever? Do I owe the seller anything? Well, honesty, fairness, and disclosure material facts, but where's my loyalty? My loyalty is to the buyer because they're the one that hired me. What if your buyer is going after for sale by owner? And you call that for sale by owner and you say, are you willing to cooperate with me? And the for sale by owner says, sure. Do I have to force that FSBO into an agency relationship? Do I have to make them hire me? No, they've already decided to go on their own. They've already decided to go for sale by owner. They just happen to be willing to pay me. Again, where's my loyalty? Is it to the buyer that hired me? Or is it to the sale by owner that says, yeah, we'll cooperate with you? My loyalty is to the person or people that enter into an agency agreement with me. And this is what I think we need to understand. My loyalty is to the buyer that hires me to buy a $5,000 tract of land, up to the seller that hires me to sell their $1 million mansion. Price point and loyalty do not matter. So if your buyer enters into an agency agreement and they say, I want to buy a chunk of land that's $5,000, what do I owe that buyer? Let me actually ask you guys, Tell me in the chat, what do I owe that buyer? They hire me, enter into an agency agreement with me. They want to buy a $5,000 tract of land. Don't have to get a loan. They got the money stuffed away somewhere. They hire me to help them find that job or find that land. What do I owe them? Even though I'm only getting a percentage of $5,000, what do I owe them? I'm loving what I'm seeing. I owe them OCAR. Once you hire me, you get OCAR. Price point doesn't matter. If you want to get paid, all of our agency agreements must eventually be in writing. We're going to talk more and more about this, start introducing this to you guys. I cannot perform a single service for the owner. May that be for list or for rent, for sale or for rent. I cannot perform a single service with the owner of a property without first entering into a written agency agreement. As we will learn at the end of this unit, we'll talk more about it, the commission allows me to work with a buyer and tenant under an oral agency agreement at first. But if you want to get paid, that oral agreement must eventually be put into writing. There's some moments of time that we need to get that oral agreement in writing. And we will talk about oral buyer agency started at the end of this unit. Again, you guys, I earn my commission when I bring this idea of this ready, willing, and able buyer, when I connect them to a seller, when I brokerage the deal, when I connect the two, that's when I've earned my commission. Unfortunately, we don't typically get paid until and if it closes. And I get lots of questions. Can I sue my buyer if they terminate? Can we sue the seller? Can we go after the seller if they decide not to accept this offer? And my answer to you is, it's not your commission. It's the firm's commission. So it's up to the firm if they want to go after the buyer or the seller. It's not up to you. And I'll be honest, I don't know many firms that want to be known as suing buyers and sellers at the drop of a hat. That's not how you get future business, is it? To me, that's the hard part of this class. Did anybody just learn that? You don't get paid until it closes. We are a commission-based industry. I wish I could stand here and tell you all that they're all going to close, but I'm not going to lie to you. Yes, ma'am.
I was wondering, what's the fastest closing you've had and the longest closing you've had? How long?
The fastest one I had was a cash buyer. It was about 3 weeks, 4 weeks, something like that. The longest one, somehow my listing turned into a 2-year lease to own. So from start to finish, I was like 2 years and 7 months or something like that. When did I get paid? I'm laughing now. I was crying then. I'm laughing now. So I'm making progress. They're not all 45, 60 days.
No, I know I'm jumping ahead, but the amount of commission that you get paid is based on the firm that you work with, the percentage that you're going to give them based on the price of the house, correct?
Mm-hmm. Percentage of the sales price. Yep.
Okay, thank you.
Mm-hmm. We get into your commission again in Unit 8, so we'll talk about how that's split, how that works. What's the average time frame? I mean, there is no average. Every market's different. Things are closing faster now than what they did 2 years ago. So we'll get more into the contract to closing process. Let's not get ahead of ourselves. We'll get it more into the contract to closing process. We talk about that Unit 21. So we'll talk more about that process and what's all involved. There's no average. I sometimes joke, you guys, I need you to take the word normal out of your vocabulary because every single transaction is different. There is no normal. Let's consider this for just a second. Every property, every buyer, and every seller are different. And that makes for a unique transaction every single time. If you have 30 transactions under your belt, transaction number 31 isn't going to look anything like the previous 30. You guys with me? Every single one is different. There is no normal. Okay.
One last question.
Yes.
What's the percentage, or like based on your experience, what's the if you've worked in a firm, what's the percentage that you've had to give them?
There is no, it's up to the firm's policy. The firm can pay you as much as they want. They can charge the seller as much as they want. Okay. I promise you, commissions coming more in Unit 8. Pinky swear. I wouldn't lie to you guys, especially about your money. Okay. All good things must come to an end, and that includes our agency relationship. Now, this is all spelled out for you on page 152. I didn't feel the need to recreate the wheel. There's different reasons, different things that can terminate an agency relationship. The first bullet point there, completion or fulfillment of the purpose in which the agency was created. Once I've done the job that you hired me to do, my job is over. So if you hire me to market and advertise and list your home and sell your home, once it sells, once that title conveys, I've done my job. Our agency relationship is over. If you hire me to help you find and purchase a home, once you've purchased it, my job is done. That will end an agency relationship. When we're done, we're done. Once I've done the job you hired me to do. We are going to learn in Unit 8 that all agency agreements have to have a definite end date. And when they're over, they're over. So if our agency agreement is up on September 27th, that means at 11:59 tonight, we are done. Can we agree to continue? Can we agree to extend it? Of course we can, but we don't have to. Unless we agree otherwise, at 11:59 tonight, we are done. A mutual agreement to terminate the agency. The parties agree to enter into the agency agreement together. The parties can agree to terminate. So if the parties agree, and remember, the relationship is between the client and the firm. Can you fire a buyer? Not without facing the consequences of your BIC. You just fired your firm's buyer, and I promise you, you don't have a happy BIC. The BIC, the firm would have to be the one to make a decision to mutually agree to release, terminate this agency. Breach of either party may terminate the agency agreement. Operation of law. Let's say you have a property listed for sale and the judge takes the property. Maybe eminent domain, maybe bankruptcy. If the judge takes the property, the seller is no longer the owner of record. The seller can't sell what they don't own. So if the judge takes the property, it's no longer the seller's to sell. And then death or incapacity of either party. If the client dies, that'll terminate the agency agreement. This is again why we need to understand. If the individual agent passes away, the agency relationship continues because the seller hired the firm. The only way for the firm to die would be if they shut their doors. If the firm shuts their doors, that would terminate. If the individual agent passes away, the show goes on. So question comes in. I'm going to ignore that first part because you getting paid is not the most important thing. What terminates the agency agreement is when the deal closes, when the title changes hands. You getting paid is a byproduct of that. So what terminates the agency relationship? When the deed changes hands. That's when I've done the job that I was hired to do. I'm going to go off textbook for a couple slides. There's some information from the syllabus that we need to get, that we need to understand when it comes to termination of agency. So please don't ask me what page we're on. We're going to go off book for a minute. Usually when our agency agreement ends, then typically all of my duties end as well. There are some exceptions. If I have yet to fulfill a promise or an obligation, even though our agency agreement ended at 11:59 tonight, if I have a promise hanging out there, I still have a duty to fulfill that. If our agency agreement ends when the transaction is under contract, it hasn't closed yet, I have a duty still to see that buyer or seller through closing. So even though our agency agreement's over, we may be 2 days or a week or a month away from closing, we're under contract, my duty continues. The suggestion here obviously would be to extend our agency agreement to closing. That way we have the paperwork, we have the documentation. If our agency agreement ends and I don't sell, it's a listing agreement and I don't sell your house, I can't use the information I learned about the seller after our agency agreement to self-deal to benefit myself and buy the house. I can't use the information that they provided me during our agency agreement against them. I now know a whole bunch of things. I know the seller's motivation. I know how low they're willing to go. I may know desired terms, closing date, that kind of thing, right? I just had a relationship with the seller. And now because it's over, I can't use that information to their disadvantage. I can't do that self-dealing. I still owe them any knowledge that I gained. I can't try to take it for my own benefit. Well, I know you had to sell this house 2 months ago, so I'm going to make you a lowball offer. That's called self-dealing. The seller kind of feels betrayed at this point, don't they? The other thing, when agency is over, guys, I don't have now, if our agency agreement ends today, that means tomorrow, I don't have a golden ticket to run around the streets blabbing your confidential information. I can't run down the street going, they got to sell because they move in and da da da. The honorable thing to do is still maintain that confidentiality. Except, this is where it gets fun. I have a house listed for sale. I never sell it, it expires. Our agency agreement is over tonight. Tomorrow, the seller calls a different firm and enters into an agency agreement with them. They relist with another firm. In the meantime, I've picked up a buyer client and now come to find out they're interested in this home. My question to you is, who is my loyalty to today? Tell me in the chat. Who is my loyalty to today? Buyer or seller? And you can tell me B or S. I know what you're talking about. Who is my loyalty to today? Look at y'all blowing my chat up. Love it. All with the right answer. My loyalty today is to the buyer, because that's who I have a current relationship with. That's the only time I'm going to break that duty of confidentiality. I tell my client everything about my customer. I tell my customer nothing about my client. So while yesterday the seller was my client, today they're not. Today they're just my customer. And now this buyer's interested, a different firm has it listed, and they say, gee, is there anything you know about this house that can maybe help me get in? As a matter of fact, I do. My duty is always to my current loyalty. But guys, that's the only exception to this confidentiality. Again, if you're representing the next, does that make sense? We don't have a golden ticket to run around, and it's called gossip, and we're not going to do that. I tell my client everything about my customer. I tell my customer nothing about my client. So the seller that's working with a different firm, they see an offer come through from a buyer, my buyer, and of course they see my name on it. Is the seller going to get a little nervous? They're going to start reviewing everything that they told me, right? Like, oh my God, I shared this with her and I told her that, and I told her this. They're going to start reviewing in their mind. Do your head one way or another. Does the seller have to accept my buyer's offer? Do they have to accept it? No, no, they don't have to proceed with the transaction. This isn't a matter of what the buyer or seller is going to do. This is my loyalty. This is my obligations as an agent. Does that make sense? I think sometimes we get nervous. That's not fair to the seller. I agree. But the seller never has to accept any offer. If they say, oh my God, there's that Julie Campbell chick. I thought we were done with her. I'm back. Okay, let's go ahead and take the break. When we come back, I got a few more off slides, off book slides, and then we'll get back in the book. So let's take 10. All right. We're back. How we doing? We doing good? Breaking down, helpful conversations, helpful. It's a lot. There's a lot involved with agency. All right, so I am going to take attendance. And again, we're still off book. By off book, I mean we are pulling information straight from the syllabus, things that the commission thinks is important that just didn't make it to the textbook. I have taken attendance, so if you're just coming back, please let me know. The consumer pretty much has two choices. They can choose to hire the sole practitioner. How many agents are affiliated by a sole practitioner? How many? What's the word sole tell you? Just one. This is a one-man show. This isn't a big Keller Williams that has 17 agents and 1,000, or 17 locations and 1,000 agents. The independent broker, the independent contractor can function as a sole proprietor or as a licensed entity. So if you ever want to go out on your own, first off, you guys got to get some experience under your belt. We will talk about that when we get to license law and commission rule. But if you're going out on your own, you don't want to affiliate with a firm, you want to be your firm, you have a choices. You can either go as a sole proprietor or a licensed entity. And that agency agreement, it was between you, the individual broker, and the consumer. Once they sign it, they become your client. Again, we will talk about the sole proprietor. We will talk about going out on your own and those requirements when we get to license law and commission rule, but you guys got a ways to go before that. First off, you got to get your license. Keep those goals in mind. Kind of the other option that the consumer has is to hire a licensed firm. This is the Keller Williams, Allen Tate, Coldwell Banker. So those agency agreements between the consumer, upon sign, they become the client, and the firm. We're going to talk about something called sub-agency. We're getting there. Let's pretend for a second. Let's pretend just for 1 second. All of you get your real estate license today. Every single one of you. Oh, yay. Congratulations. This is a good day, right? Every single one of you just got your license. And now that you're all licensed, you decide to come work for me. And I have a firm called Julie's Real Estate Shop. So you get your license and you come work for me. Who's the firm? Who's the BIC? Me. You all are affiliated with me. If one of you gets a listing, maybe it's a listing that you sought after, maybe it's somebody you know, friends, family. When one of you gets a listing, again, I ask you, whose listing is it? Is it yours? No, whose is it? It's mine, Julie's Real Estate Shop. Yes, I allow one of you to work with my seller. You are welcome. So one of you gets a listing. By default, the rest of you are sub-agents. You are agents of an agent. You are an agent of me. So even though one of you has the listing, one of you is going to be in contact with the seller, one of you is going to do all the work with the seller, the rest of you still have duties to my seller. And that's what a sub-agent is. Now, you're never going to talk to this seller, but you have a duty not to harm my seller in this transaction. And that gets us started on the sub-agency relationship. We will get there in just a second. But for right now, let's just understand, when one of you gets a listing, in a sense, all of us get a listing because it is my listing, not yours. So that leads us into our next discussion. And our next discussion, back to page 152, 153, is the different agency relationships. These are the types of agency relationships that the Real Estate Commission allows firms to have. Some firms operate this way, some firms don't. You guys, especially with these first couple that we're going to look at, you guys tend to get all upset. Why would somebody do that? I don't know. But the Real Estate Commission gives them the option. The Real Estate Commission says, these are the options you have in working with buyers and sellers. I also think you guys, sometimes you get in your own way. And we're going to go through this discussion and you may be thinking, well, I'm not going to affiliate with a firm that only works with sellers. I want to affiliate a firm that works with both buyers and sellers. And that's good. I'm happy for you. Your test is not going to ask you what you're going to do. Your test is going to ask you what you can do. And that's what this discussion is. The different types of agency relationships that the firm can have with the consumer. Do I have everybody on board? Y'all get out of your own way. I promise you, I'm not going to do that. Good, good. Can you? And that's what the commission is going to ask you. That's what your test is going to ask you. These types of agency relationships summed up nicely. Page 153, nice little box there, a graph there, kind of help you with the highlights. The first type of agency relationship we have is a single agency relationship. And in this case, that single agency relationship, the firm only represents sellers. The only person, the firm's policy says, for whatever reason, I don't know why, but for whatever reason, the firm says, the only people that can hire us are sellers. Sellers are our clients. We will never have a buyer client. All of our buyers are going to be customers or represented by another firm. Another firm can bring their buyer client. This firm only works with sellers, only represents sellers. We don't see this much in our populated areas. So you're not going to find many firms in the Triad, Triangle, Charlotte that practice this. I think where we see this more often is more in our rural areas, less populations. But it's out there and it's allowed. The commission will allow a firm to only represent a seller. Flip that coin. Another example of single agency are firms that only work with buyers. We don't take listings. We don't sign listing agreements. We don't have a product for sale. Our clients are the buyers, which means everything we show our buyer is going to be property either listed by another firm or a for sale by owner. You'll never see a for sale sign in a front yard with my firm's name on it. Why? Because we only represent buyers. We have firms out there that will work with sellers or buyers in one transaction, but never both. So if the seller has hired you to list their home for sale, the buyer's a customer or the buyer's represented by another firm. If the buyer hires you to help them find a home, you can't show them something that your firm has listed. It's one or the other, but never both. When we can work with both, we're getting there. Bear with me. So single agency meaning I'm only representing one side. May it be only sellers, may it be only buyers, or may it be one or the other in the same transaction. Questions on that? Single agency, one client. Page 155, we start talking about sub-agency. First off, the prefix sub means under. So when we're saying sub-agency, basically what we're saying is an agent of an agent. You're an agent of the agent that's been hired. Our example a few minutes ago, you all get licensed, you come affiliate with Julie's Real Estate Shop. One of you gets a listing, which means I allow one of you to work with my sellers. By default, though, the rest of you are a sub-agent. Because whose listing is it? I need reminded one more time. Whose listing is it? Is it yours? No, it is mine. So all of you have a duty to treat my seller right. All of you. Even though one of you is only working with them, one of you is going to get paid. It's not your listing. It's mine. Have you guys ever been to an open house? Have you guys ever just kind of wandered in and out of open houses? That's a great way to start meeting your market. As we start having inventory again, I think we're going to start seeing open houses come back. So you may go open housing. It's a fun way to kill a Sunday afternoon. And if you're going to an open house, you may pull up to the house. You may see a for sale sign in the front yard. And let's say the for sale sign in the front yard says Julie's Real Estate Shop. And then it has also the agent named Sally. And you saw Sally's marketing and you saw Sally's advertising. That's what got you to the open house. You see Sally's name on the side. And you walk into the open house and the agent is there to greet you. And the agent says, "Hi, welcome to the open house. My name is Susie." And you think, well, Sally's the listing agent. Who's this Susie person? Susie's an agent of my firm. Susie's allowed to do the open house because Susie's affiliated with me. Maybe Sally wants to do her own open house. Maybe Sally's been in the business for 30 years and she's overdoing open houses. And so she relies on brand new agents just coming out of real estate school to do her open houses for her. What a great way for new agents to meet buyers. When you guys affiliate with your firms, I want you to march up to the top producer in your office, look them square in the eye and say, "I love doing open houses." What a great way for you guys to start meeting buyers. You know what seasoned agents do not like to do? Open houses. There's your free advice for the day. Don't say I never gave you. Okay, everybody with me? Anybody in the firm can do that open house because all of our loyalty is to me, the firm. Yeah, you guys are welcome to go open house. They're open to the public. So somebody just said you've seen some open houses in your neighborhood. There's that word normal again, but is it acceptable for you to stop in? Absolutely. Absolutely. What a great way for you guys to start seeing the product, the inventory, the market that you want to work. Y'all just don't go into that open house acting like a super serious buyer. If you're just going in as a pre-licensing student, then just say, right, just be honest, please. As an agent that has done open houses, we've learned to spot you. So just be honest. But yeah, open houses are open to the public, go nuts. Maybe you'll meet the agent on the sign, maybe you won't. They're affiliated with the same firm. That's one version of sub-agency. One of us gets a listing. In a sense, we all get a listing. It's by default of the firm. What questions do I have on this piece, this version of sub-agency before we talk about the next? Do you get paid? Maybe somebody will pay you. I've never been paid to do an open house for somebody else because we're a commission-based industry, but maybe somebody will pay you. I'm not saying they will or won't, just ask. Your purpose of doing the open house would be to find a buyer to work with. Maybe in that transaction or maybe in another. My very first buyer closing I ever had, I met at an open house, top producers listing. Very first buyer I ever closed. They called me on Monday. They said, "We liked your presentation. You seem really nice. We're not interested in that house, but will you help us? Will you help us buy one?" And I said, Yes, of course, I'd be so glad to. Thanks for calling. Sub-agency. When one of us gets a listing, we all get a listing. We are an agent of the agent. The second version of sub-agency is when you're the agent and you're working with a buyer customer. The second version of sub-agency, the other way the sub-agency can look is when you're an agent working with a buyer customer. Guys, when I wake up every morning, I have a duty to every single seller that has a house listed for sale in the Triad MLS. My duty, my responsibility, my obligation is to all the sellers that have a home for sale in the Triad MLS. And my job is the idea of finding them this ready, willing, and able buyer. Maybe that buyer will hire me and become my client. Maybe they won't. My job is to find a ready, willing, able buyer for the sellers. If the buyer doesn't hire me, if the buyer chooses to go unrepresented, then I proceed as a seller's subagent. In order for you to be involved in the transaction, you got to have a role. And if the buyer's not going to hire you, your role, your duty, your obligation is owed to the seller. The buyer's the customer. The seller has hired somebody. Maybe it's your firm, maybe it's a different firm. The seller has hired somebody. The buyer wants to go unrepresented. So you proceed as a seller subagent. Let's imagine, if you will, agency is divided by a wall. So here's our agency wall. You have the seller on one side of the wall. You have the buyer on another side of the wall. Real estate transaction right there, right? Buyer and seller, other side of the wall. The seller has hired an agent. The seller has hired somebody to stand on this side of the wall with them. The buyer has not. The buyer doesn't want anybody standing on this side of the wall with them. So with you working with your buyer customer, you have to have a role. And in this case, your role is that of a seller's subagent. Not all firms, not all sellers allow seller subagency. The firm has to have a policy to allow it. The seller has to agree to allow the firm to allow seller subagency. A reason why the firm and or the seller may not allow seller subagency is something called vicarious liability. Have you guys ever heard of living vicarious through somebody? You're living vicariously through somebody. If you're a subagent, a seller subagent, you are living vicariously through the listing agent. And what vicarious liability says is the seller or the listing agent could be held liable for your actions. They could be responsible, or let me, if I could rephrase that, your misactions, your mishandling of the transaction. And if this subagent comes from a different firm, you may not know this person, you may not know what kind of training you had, you don't know what kind of experience they have, you know nothing about them. Do you want to be responsible for their actions? Do you want to be responsible for their misactions? The firm may or may not allow it. When you put a listing in the Triad MLS, I can't speak for other MLSs. I can't imagine this piece being any different in other MLSs, but specifically for the Triad MLS, you have to select what type of agency the seller will allow. And the MLS will tell you who is welcome. Is it the buyer's agent, the seller sub-agent, or both? So if you're acting as a seller sub-agent and the MLS says buyer agent only, can you show that property? No, you cannot. Because the seller and the firm has said the only agents that can bring their buyers into my front door are the buyer's agent. The only agents we want to have are those that are working with clients. Now, I hear you guys. Do I get paid as a seller sub-agent? How do I get paid? Da, 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 da. I hear you. Our listing agreement breaks it down. Seller pays the listing firm. Listing firm shares their commission with whomever brings the buyer. Our agency agreement breaks it down. And it says, this is how much we are willing to pay a buyer's agent. This is how much we are willing to pay, if any, a seller sub-agent. So you know, not only if you're allowed to show that property or not, but you also know as a seller sub-agent how much you're going to get paid. What questions do I have? By the way, this idea, this ready, willing, and able buyer, I always think of a three-legged stool. I need all three legs, right? What happens if you kick one of these legs out? The stool falls over, doesn't it? So when I'm bringing a buyer, I'm not just bringing anybody. We're not just out kicking tires. I'm bringing you this three-legged stool. Ready, willing, and able buyer. The question to the seller and the firm is, what role do I play in the transaction? If I'm a buyer's agent, if I've been hired, then I'm going to be on this side of the wall with my buyer. If they don't, they choose to go unrepresented. They choose to be on that side of the wall by themselves. What questions do we have on this?
This might be off the wall a little bit, but do people usually have an agent for a buyer side?
Are you asking if buyers usually hire agents?
Yeah.
Yep. I think the typical, the most common transaction, seller and buyer both have representation.
Perfect.
Examples of buyers that may not have represented, just in my experience, sometimes investors, home flippers, people that do this for a living. I mean, y'all, they may buy and sell 10 to 20 houses a year. They don't need me. They just need me to get them in the front door. They don't need to be represented. They know what they're doing. Those investors or flippers might be a reason why they choose to go unrepresented. The buyer doesn't have to hire anybody. I mean, shoot, buyers and sellers buy and sell houses every day without any agents. There's no requirement that says anybody has to be represented. They're choosing to hire us. You have an unrepresented buyer going after a for sale by owner. Happens every single day. Takes us back to what we talked about last week. Y'all remember that transactional broker? The facilitator broker? In order for us to be involved, somebody's got to be represented. And in this case, the seller is the one that is represented. That's how we get in as a seller sub-agent. Somebody's got to be represented in order for us to be involved in the transaction. Again, you're not going to see this every day. You may see this a couple times in your career. It's going to be on your test. We need to know how to handle it. We need to know what this means. Remember our goals, you guys. We got to get you through the tests. The seller sub-agency out there? Yeah, absolutely. Is it allowed? Sure. Do your head one way or another. If I'm the subagent, seller subagent, and I'm working with the buyer, not for the buyer, with the buyer, I'm working with the unrepresented buyer. Do I still have a duty to explain what that subagency relationship looks like to the buyer? Yeah, absolutely. Absolutely. Implied agency is never allowed. So the buyer says, I don't want to hire you. That's fine. You need to understand, if you choose to go unrepresented, my loyalty is to the seller as a seller subagent. So who do I tell all confidential information to? The seller. Be careful what you tell me, because you chose not to hire me. You left me no other choice but leave my duties and obligations to the seller. What is the seller subagent role in this transaction if there's already a buyer? That's a great question. So what's the seller subagent going to do? They're going to get this buyer through the transaction. I'm still going to assist them. I'm going to walk side by side with them. But getting through the transaction is what's in the best interest of my seller. They're going to be in coach. The buyer's going to be in coach. So they need to get in the front door. I can give them access. For example, when they say, Julie, how much should I offer? I want to make an offer. How much should I offer? Who's my loyalty to? Who's that offer have to favor? The seller. They chose not to be represented. The buyer is the customer. Did y'all write that down? Seller subagency. The buyer is the customer. We're good for now. You guys got to spend some time with subagency again before we leave today. I'll give you some other places to look. Another type of agency relationship is when both the buyer and the seller in the same transaction hire the same firm. The firm represents both, and this is called dual agency. If I can, I got several slides here in this discussion. If I can, let's hold all questions until the end, because it very well may be I answer your question as we go. So stay with me for a few slides. I promise I will open up for questions when we're done talking about dual agency. So just bear with me for a few minutes. Dual agency is an in-house transaction. What do we mean by in-house? How many firms are involved with in-house? Just one. The seller hires firm Julie's Real Estate Shop to sell 123 Main Street. Julie's Real Estate Shop is working for the buyer that wants to purchase 123 Main Street. It's an in-house transaction. The simplest breakdown I have figured out to give about dual agency. It's one firm, one transaction, two clients. Dual agency may be one or two brokers. You could have single agent dual agency, where one agent is working with the seller and the buyer in the same transaction. You could have two brokers from the same firm, one working with the seller, one working with the buyer. Who did the seller and the buyer hire? They hired the firm. Dual agency is intentionally created with informed written consent. Let's break that sentence down. Very important. Does dual agency just automatically happen? No, it is intentionally created. It's purposely created. It doesn't just happen. It's got to be created. How do we purposely and intentionally create that? We have informed written consent of both parties. The seller has to agree to allow dual agency. The buyer has to allow to agree dual agency. So let's talk for just a minute about what dual agency looks like. Do I have, let's see, what sport are we in right now? College football. Did you guys spend any time this weekend watching some good college football games? Anybody get to go to Wake Forest? That would have been a fun weekend too. So let's talk football for a minute. When you're sitting in the stands watching a football game, is it pretty clear when you look in the field that there's two teams? Can't you tell that there are two teams on the field, both doing their own thing? So in a real estate transaction, let's put the seller and the buyer on the field. The seller's one team, the buyer's the other team. And they're both doing their same thing. They both have their end goal. They both want to win. Seller wants to sell, buyer wants to buy. If we represent one, buyer or seller, think of our role in the transaction as the coach. We're standing in the sidelines. We're making sure our players do what they're supposed to do. We're helping them get through the game. When we enter into dual agency, my role changes. The seller's still selling and the buyer's still buying. They haven't changed. When we enter into dual agency, my role changes. I go from being the coach to the referee. Is the referee still involved in the game? Yeah. Is the referee still an important part of the game? Absolutely. Is the referee telling the players what play to make next? Is the referee giving advice? Are they saying, make this play, throw that ball? Not if they want to keep their job long, right? So in a dual agency, my role changes. I go from being the coach to the referee. As a dual agent, I can't give full old card to both buyer and seller. They got to give something up if they agree to do this dual agency. And what they are giving up is advocacy. Now that I'm a dual agent, I can't be on the sidelines. Now that I'm a referee, I can't be on the sidelines shouting advice. There is no advice that the firm can offer one party that won't harm the other. So my ability to give advice, if they say, what should I do? The buyer says, how much should I offer? Well, if I say full, if I just blurt out full asking price or more, I may have harmed our buyer client. Maybe the house was overpriced to begin with. If I say offer under asking price, now I've hurt our seller client. What if the seller, we get an offer from a buyer in our firm, buyer client in our firm, and the seller says, this is an okay offer. Should I accept it? Should I counter offer it? What should I do with it? If I say accept it, I may have harmed my seller client. Maybe I could have gotten them more money. If I say counter it, I've harmed my buyer client. You guys see where we're heading? There's no advice in dual agency that you can give one party that doesn't affect the other. So in a dual agency transaction, I'm serving two kings now, aren't I? I got the seller king and the buyer king. Do kings like that? Typically not. And how we work through it, how we navigate through it, is that we stop with that advocacy. We stop giving advice. Guys, you were with the seller before this buyer came. Can't you have conversations before dual agency? So when you're with the seller and you're like, okay, so when we get an offer and this is what's going to happen, walk through the process with them. Same thing when you work with the buyers. When you find the one, make an offer, we go into contract, you're going to want to get a home inspection, pest inspection. We can advise our clients before we enter into a dual agency agreement. Dual agency, all you need is one listing and one buyer client to be interested in that listing. If I were a sole practitioner, I'm a one-man show, it's just me, and I get one listing, and I put my for sale sign in the front yard, and I have one buyer call off of that one listing, I'm now in the potential for dual agency. Dual agency is a phone call away. What if you're not a sole practitioner? What if you work with a firm with 1,000 other agents, 999 other agents? Now the firm has a couple hundred listings. All we still need is one phone call, one inquiry off of our sign, off of our listing. So I think sometimes people think, well, dual agency only happens in big firms. Dual agency is always a phone call away. You have one seller client, you pick a buyer up that's interested in hiring you, and now they're interested in your listing, and now we're in dual agency. Flip that coin. You've been working with a buyer for months and months and months, and they've seen everything on the market. They've exhausted the market, and they're going, oh my gosh, Julie, what do I do? And today, my firm puts something on the market that they're really interested in. I've been with that buyer client for months, but today we now have a seller client. Are we in potential for dual agency? Yeah, 2 clients. One doesn't have to come before the other. I think the more common is we have the listing and then the buyer calls on it. But there are times when you're working with the buyer, the firm lists a property for sale. We have to have these conversations about dual agency with potential buyers and sellers before dual agency happens. When we look at our listing agreements, next unit, both listing agreement and buyer's agency agreement talk about dual agency. It gives us the opportunity to have the discussion, and seller and buyer have to agree to allow it. So you're working, you get a listing, you get a call to list my house, you're meeting with the seller, and you're sitting in their home doing the listing paperwork, and you're going through the listing agreement. And you get to the section in the listing agreement about dual agency. And you have a conversation with your seller about it. You have a discussion, you explain it to them. It's not their job to know dual agency. It's your job to know it, to explain it to them. Most people in their right mind, when they hear about dual agency, when they say, I fully represent you and I owe you everything, unless my firm represents the buyer in the transaction, then I take a few steps back and I can no longer offer you advocacy. Do you think sellers generally like that? Do you think they like hearing, I can't give you that advice? They don't have to agree to dual agency. They have the option to say no, but this is what they need to understand. If they say no to dual, no agent in the office can bring their buyer client or in the firm. No agent in the firm. If they're saying no to dual, what they're saying no to is the firm bringing any of their buyer clients. If you're a one-man show, that may not be a big deal. Okay, so it's just one person, you can't bring your buyers, whatever. What if you're a firm with 1,000 agents? And you're looking at that seller saying, if you say no to dual, there are 999 agents, including myself, 1,000 agents out there that can't bring their buyer clients. Is the seller going to say yes to that? I don't know. They have that choice, but we have to explain it to them. What if the buyer isn't a client? What if the buyer is a customer? If the buyer is a customer, is there a potential for dual agency? If it's a customer, are we in dual? No, because dual agency is one firm, one transaction, 2 clients. So if the seller's the client and the buyer's the customer, dual agency isn't an option. In order for us to be in dual, we got one firm, one transaction, 2 clients. Maybe it's one broker working both sides. Maybe it's 2 brokers within the same firm. Maybe you know the other broker, or maybe you don't. If you affiliate with a firm with 1,000 agents, it's going to take you a while to meet everybody. So maybe you know that other agent, maybe you don't, but we're all affiliated with the same firm. So dual agency, the firm represents both buyer and seller with equal loyalty and the same transaction. How in the heck do we do this? First off, and most importantly, I got to have written permission of all parties. Remember earlier we mentioned undisclosed dual agency. Undisclosed dual agent, I just start acting like a dual agent without discussing, without getting your informed written consent. Dual agency is intentionally created with informed written consent. And I somehow have to navigate this without compromising either principle. Now, let's be clear. Even if I were a single agent, dual agent, I still don't have a golden ticket to tell the seller all the buyer's information and tell the buyer all the seller's information, right? I'm still going to keep my party's information confidential. We just gave the example of, sellers. Same thing with buyers. You're working with a buyer, maybe you've been working with them for months, and maybe because you're a good agent, when you first met them 2 months ago, you had the conversation about dual agency. But for the last 2 months, you guys have been out looking at property listed by other firms. So in the last 2 months, this dual agency thing hasn't even been an issue because somebody else has listed it, or it's a for sale by owner. And now 2 months into the relationship, your buyer wants to see something that your firm has listed. We need to revisit dual agency, right? Because I'm sure they forgot about it. Before we see this property, you need to know my advocacy. If we move forward, my advocacy goes away. If we move forward, I have a duty to represent both buyer and seller. If you guys are bearing with me, I do have a possible solution for dual agency. This does not sound good for buyers and sellers, does it? I mean, if you were hiring me and I'm saying, well, there may be a chance that I can't give you my advice. This isn't what's in the best interest of the buyer or the seller, right? This is going to help us get through the transaction. And in order for this buyer and seller to be on board, we have to have that informed written consent. I do have a possible solution for dual, so just hang in there with me. We're getting there. We mentioned earlier, we were talking about our conflict of interest. A conflict of interest is undisclosed dual agency, which means you just start acting like a dual agent without first having that informed written consent. We got to have permission from both sides before we can act as a dual agent. The buyer's permission may be oral at first. We'll talk about oral buyer agency. The seller's permission has to be, or non, has to be in writing from the onset. I cannot perform a single service for a seller or an owner of a property without having a signed agency agreement. By the way, thank you, Forms Committee. Dual agency agreement used to be a separate form. And probably about 10 years ago, the Forms Committee just put it in our listing agreement and our buyer's agency agreement. So now it's just all right there for us, which is nice. So dual agency, particularly disclosed dual agency, is purposely created. It's created with informed written consent. And I cannot share confidential information about one party to the other. Dual agency, one firm. The seller has hired the firm to sell. The buyer has hired the firm to help them buy. The same transaction, 123 Main Street. Both buyer and seller are clients. They've both hired the firm. If either one of them don't hire the firm, then we have a client and a customer, and we don't have the potential for dual agency. If we do you guys like pictures? Remember our agency wall? So our agency wall, what dual agency looks like, you got the buyer on one side, seller on the other, and the firm and all the agents of the firm are now going to be straddling the wall. We're not on either side of the wall. We are straddling it 50-50. Okay. Oh, let me ask you guys one more question. Do your head one way or another. If I'm a dual agent, if I'm a single agent, dual agent, do I owe my buyers and sellers a disclosure of material facts? Yes, because the answer is I always have a duty to disclose material facts. I don't care who you are. Are you a client or a customer? I owe you material facts. The other piece of that, you guys, I don't care what my role is. Am I a listing agent? Am I a buyer's agent? Am I a seller sub agent? Or am I a dual agent? I always have a duty to disclose material facts. Okay, your turn. What are your questions? Mulling it over. Disclosed dual agency. That's the word you're missing there. So disclosed dual agency means I have informed written consent. Undisclosed means I don't. And that's what's not allowed. Dual agency is purposely created. Let's go ahead and take our break. When we come back, we're going to talk about the possible solution. We're not done with dual agency yet. I may have an answer for you guys. So let's take 10. Did we come back? This is good stuff, isn't it? So I think one thing that we've already established, yeah, and I need to take, I got excited. I was ready to go back into it. Let me take attendance first though. Hold that thought. Okay, so let me take attendance, smile. We've already established that dual agency is not what's necessarily best for the buyer or the seller. Dual agency is what's best for the transaction. You have a seller that wants to sell this house. You have a buyer that wants to buy this house. And thank you guys for telling me that you're back. I have already taken attendance, so thank you. So dual agency isn't always what's best for the seller. But I think as agents, we have a hard time wrapping our brains around this. The first day of class, you guys sent me an introduction of yourself. And a lot, and if you haven't yet, still do, you can, still can. A lot of you tell me on the first day that you have signed up for real estate school because you like people and you want to help buyers and sellers achieve that dream of buying and selling a home. You want to help people, you want to assist people. And that's why you're here. And that's a great place to start. But now I'm standing here babbling on about opportunities that you may not be able to fully assist the buyers and the sellers that you want to work with. And again, you guys, that's where we need to understand our role. It could be that there's somebody else in the firm that's working with the other client, buyer or seller. You're working with one, they're working with the other. Maybe you know each other, maybe you don't. It's the relationship with the firm. If you happen to be in one of these big firms that has multiple office locations, let's say your firm has a location in Greensboro, High Point, and Winston-Salem. You have 3 offices within the firm, yes? Dual agency is with the firm. So the agent in Winston-Salem may list it, the agent in Greensboro may bring the buyer. But as long as we're all under the same umbrella of the firm, we're still in dual agency. Because remember, the firm is who the relationship is with, not the individual agent. Do we have any questions? Please, thank you guys for telling me you're back. Yep. Yeah, we've taken attendance. So I've heard from some of you. Make sure the rest of you please tell me. And by the way, when we talk about sharing information, confidential information, this is information that's related to the transaction. Personally, I don't care what you had for lunch today. That's not considered confidential information. You with me? It's something that's affecting the transaction. What's your willingness to buy? What's your motivation to sell? What's the price point you're looking at? It's something about the transaction. You can see on page 159, it kind of gives us some examples of things that we need to keep confidential. Willingness to accept any terms, motivation for buying or selling, confidential information unless we have to disclose a material fact. Remember, one of our particular material facts is your principal's inability to complete the transaction. So if you're a single agent, dual agent, and you find out your buyer can't get loan approval, do you have to share that with your seller? Your buyer can't buy the house. Do you share that with your seller? Yes, that's a material fact that we have to share. Could your buyer be embarrassed that they can't buy the house? It affects their ability to complete the transaction. When it comes to disclosing material facts, let me say it one more time for the guys in the back. We always have a duty to disclose material facts. I don't care who you are. I don't care what role you're playing. We always have a duty. And one particular material fact is your principal's ability to complete the transaction. So before the break, we mentioned that I have a possible solution for dual agency. I need you guys to hear the word possible. This is not automatic. This is not guaranteed. If the firm allows it, we can have a conversation about a designated dual agency. So I will talk about the firm's policy in just a second. But let's first talk about what designated dual agency is and what it looks like. And again, if you will hold your questions off for just a second, I will open up for plenty of time when I'm done here in just a few slides. Designated dual agency is a form of dual agency. Does everybody see that? What's it say? Designated dual agency. In order for us to enter into designated dual agency, first off, let's recap. What is dual agency? One firm, one transaction, two clients. As dual agency, simply as I can get it. Designated is a form of that. So it's still an in-house transaction. Buyer and seller are both the clients. If the firm allows designated dual agency, they have to have a written company policy in place to allow it, how they're going to practice it, how they're going to handle it. I think a common misconception that we have is everybody offers designated dual agency, and that's not true. The firm has to allow it. If the firm allows it, we can make this option available to the buyer and the seller. Both parties still have to agree to it. Here's our informed written consent again. We got to get their yes to dual. We got to get their yes to designated dual, if allowed. Remember in dual agency, we said the illustration of dual agency looked like this. We got the buyer on one side of the wall, seller on the other, and the firm and all the agents are straddling the wall. This is dual agency. If the opportunity for designated comes up, this is where designated differs. Designated dual agency will always be two brokers. You cannot have one agent be designated to work both sides. So dual agency could be one agent, it could be two agents. Designated is always two agents. And what happens in designated dual agency? The broker in charge designates one broker to work exclusively with the buyer. In a sense, that broker in charge kicks one of you off the wall. I say, Sally, I designate you to work exclusively with my buyer. And then the broker in charge kicks another agent off the wall, a different agent off the wall, to work exclusively with the seller. Look at where Sally and Bob are now. They're on either side of the wall, aren't they? Sally's over there with her buyer. Bob's over here with his seller. The firm and all the other agents, everybody that's not Sally or Bob, the firm and all the other agents remain in dual. They continue to straddle the wall. So let's back up and talk about this firm's policy. The firm has to have a policy about how we're going to designate. The broker in charge needs to ask each agent some questions, particularly, do you know anything about the other party in this transaction that can harm them? Because doesn't the firm have a duty to still protect both buyer and seller? So before I can kick you off the wall, don't I have some questions for you? Sally, do you know anything about my seller? And if Sally says, no, no, I've never met this person before in my entire life. All right, Sally, I'm going to kick you off the wall. You're going to work exclusively with my buyer. And then the broker in charge goes to Bob. Bob, do you know anything about my buyer? Maybe Bob does. Maybe they go to church together. Maybe their kids play soccer together. Maybe Bob worked with this buyer 6 months ago. Somehow Bob knows something about this buyer. My firm policy says that the BIC can only designate you, can only kick you off the wall if you don't have prior confidential information. So the BIC has to verify that, you guys. And when the BIC looks at Bob and said, do you know something about my buyer? And Bob says, yeah. I can't designate Bob. I can't kick Bob off the wall. So now I got to go to somebody else. Now maybe I go to somebody else in the firm and say, Ben, what about you? Do you know something about my buyer? No, I don't know anything. All right. Ben gets kicked off the wall. Bob remains in dual. Y'all get out of your own way. Yes, I will get Bob paid a referral fee. Bob did some work and he deserves to be paid. So we'll get Bob paid anything. It depends on the firm's policy. Don't worry about your compensation right now. Worry about how you're forming these agency relationships. Worry about how you're creating this agency relationship. Some firms that may not allow designated dual agency are our smaller firms. If my firm consists of me and my husband, do you think it's reasonable we know about each other's transactions? We know about each other's clients? Designated dual agency may not work for us. There's just two of us. We eat dinner every night together. So it might be that we have prior confidential information. We may be a firm that's a good example that doesn't allow designated dual agency, which means we just stay in dual. We don't designate, we don't kick anybody off the wall. By the way, once you've been kicked off the wall, Sally and Ben, they now proceed with their clients. They might as well be with two different firms. Sally exclusively works with her buyer. Ben exclusively works with his seller. What's the word exclusive tell you? Let me ask you guys this. If you're dating somebody exclusively, how many people should you be dating? Just one. Women always answer that more quickly than men. I have yet to figure that one out. If you're dating somebody exclusively, and that's what we mean by an exclusive relationship, Sally's only dating, the buyer's only dating one agent. The seller's only dating one agent. The two proceed as if they were with two different firms. Dual agency does not go away. All the other agents in the firm are still straddling the wall. We are all still in dual. It's just the two that we allow to be designated. There's some caveats with designated dual agency. First off, we have to have a firm policy. Do I have everybody on board with me? Do your head one way or another. Do all firms allow designated dual agency? Is there a requirement that says that they have to? Absolutely not. The firm can choose. If we allow it, we have a company policy. And again, there's a place in our agency agreement that for the seller to agree to dual and designated. We got to get informed written consent of both. First dual, then designated. So the firm allows it. The caveats. If you have received prior confidential information about the other party, you can't be designated. Are you allowed to lie to your BIC? No. No. So if your BIC says, do you know something about the other side that can harm them? If you say yes, the BIC's not allowed to designate you. This second bullet point is the biggest problem topic in Unit 7. It very well may be the biggest problem topic in a 75-hour pre-licensing class. Designated dual agency. The broker in charge and the provisional broker cannot be designated opposite of each other. So in other words, you have the firm with all the agents, you have the buyer over here, seller over here. The provisional broker cannot be kicked off the wall opposite of their broker in charge. This is never, ever allowed. The reason being, as the broker in charge, when you join as a provisional broker is your status when you first get your license. You're a newbie, you're a broker with training wheels. And whatever firm you join with, your broker in charge should be in your back pocket. They probably went with you to this listing appointment. They might have been sitting there when you had the buyer consultation appointment. They coached you, they advised you, they mentored you through these transactions. Is it safe to say that if the BIC is doing their job, they know something confidential about the provisional broker's client? Absolutely. The nature of their relationship prohibits them from being designated opposite each other. Any other relationship is allowed. You can have any other relationship be designated opposite each other as long as either side doesn't have prior confidential information going into it. Could the BIC be designated with another broker in their office? Sure, as long as they don't have prior confidential. Now, does that get tricky? Sure. And it might be the firm's policy to say the BIC can never be designated. What's your test going to ask you though? Can the BIC be designated with a broker? And the answer is yes, as long as they didn't receive prior confidential information about the other side. This is what I think the problem topic is. I'm going to hit it head on. The BIC and the provisional broker cannot be designated opposite of each other. They can be in dual. So you're going to see practice questions if you haven't already. You're going to see practice questions. It's going to say BIC and PB are in dual together. And your first thought is going to be like, oh, they can't do that. Yes, they can. They can be in dual together. They can't take it a step further and be kicked off the wall. They cannot be designated opposite of each other. Questions? Does this make us feel a little bit better? Designated as an option, designated as, I tell you, buyers and sellers like this a lot better. And if they're hemming and hawing over dual, then you, if your firm offers it, then you can say, I'll tell you what, if you agree to dual, we may be able to take this a step further. I can't guarantee you guys, because both parties have to agree to designate it. But what I can tell my client that isn't sure is that if you agree to dual and you agree to designated, we may be able to do designated. You guys with me? We still got to get the other party to agree to designated. If the firm offers it, I don't know why they wouldn't agree to have exclusive representation. That's the key. That's the kicker. The firm has to offer it. It's not automatic. Some firms do, some firms don't. Can I erase all this pink? Does everybody have everything? So once we're designated, you got an agent that's been kicked off the wall to work with the buyer. You have a different agent, same firm, that's been kicked off the wall to work with the seller. The firm and all the agents are still straddling the wall. Again, dual agency does not go away. Now that these two agents have been designated, one to work exclusively with the buyer, a different one to work exclusively with the seller. Now that these two agents have been designated again, they might as well proceed as if there were two different firms. So let me ask you this. After designation, if you're the agent that's working with the buyer and you somehow learn something confidential about the seller, do you have a duty to share that with your buyer? Do you have an obligation to share that with your buyer? Yeah. Because look at the side of the wall you're on. You're no longer straddling the wall. You're now hanging out over here with the buyer. That's what we mean by exclusive representation. That's what we mean by now you might as well proceed with two different firms. So you're skipping along in life and you learn something about the seller. Maybe you learn their motivation for selling. I don't know, something about the transaction. And you learn the seller's motivation. You're designated to work with the buyer. Who's your loyalty to? Who's your duty to? The buyer. Remember our football analogy a few minutes ago? In dual agency, we became referees. Once you're designated, you go back to being a coach. Once you're designated, you go back to being a coach. The firm is still acting as the referee. The firm is still in dual agency. But now you get to be the coach on the sideline, shouting things out, helping them get through what's best for them in the transaction. Do we feel a little bit better now knowing designated is an option? A little bit. If this is super important to you, when you are interviewing firms to affiliate with, ask them, do y'all allow designated dual agency? You're gonna say yes or no. If they say no, and you don't like that, don't join that firm. It's pretty simple. This is one big reason why I want you guys to talk to 2, if not 3 firms before you sign up. Ask questions. So let's say you hear their broker at a lunchroom sharing information on how motivated you are, the seller. Are you allowed to share that information? Would you get in trouble with the firm? That's a great question. So let's back up. Let's walk through that scenario. You guys are all licensed and you are working for Julie's Real Estate Shop. When it comes to what information I can and can't share, the kind of general rule of thumb, I can talk about the property all day long. 2-bed, 3-bath, garage, land, location, whatever. The stuff that you guys see on Zillow and Realtor.com, the property information, we can talk about that all day long. The problem, the concern comes up when the conversation switches gears from the property to the people. So let's say you all work for Julie's Real Estate Shop and we have sales meeting this morning and we're going around the room and we're, doing our agenda and this is the upcoming events that we have and da-da-da-da-da. And then I look at you guys and I say, does anybody have a new listing they'd like to share? And one of you pop your hands up and say, yeah, I got something coming on the end of the week. It's a 3-bed, 2-bath. This is where it's located. It has a garage, just adorable. It's going to sell fast. Did you learn anything about the people? Did you just learn anything at all about the people? No, all you learned about was the property. Well, let's say I'm not a good bit and I'm not paying attention and you keep talking. My sellers, God bless them, they got to sell really fast because they're in a bad situation right now. So the sooner I can get this house sold, the better. Did you just learn something confidential about my sellers? Because your peer blabbed, your peer said too much, and me, the Bic, wasn't paying attention to stop them. Guess what? All of you that were at sales meeting today can never be designated. So should we walk around the office sharing our clients' confidential information? I call it water cooler gossip. There's no rule that says that we can't because we're all under the umbrella of the firm. But what you need to understand is if you do, you've prevented yourself from being designated should that opportunity come up. So in our scenario, who's the agent that's going to get designated? The one that wasn't at sales meeting today. And if I have 100% attendance, designated is no longer an option for this transaction because you guys now all know that seller's motivation to sell. Best bet. Talk about the property. If you're talking about the people, better be to me. Better be to the Bic. I know we think we're helping sometimes. You know, sometimes we're in the break room and we're over the box of donuts. And like, man, I got a listing, and you're like, man, I got a buyer. And come to find out, ours are interested in the same transaction. The concern is, how much should we share about that buyer and seller before we got to the realization that the same transaction may work? You guys with me? So you might start talking about your seller's motivation or your buyer's needs because you think you're helping. But what you've done is prevented yourself and possibly your buyers and sellers from being in designated dual agency. Water cooler gossip is what I call it. Have a good week. Okay. So let's kind of sum this up a little bit. Designated dual agency does not go away. There's only two people that are designated. One's been kicked off the wall to work with the buyer, different one's been kicked off the wall to work with the seller. Dual agency still is in play. The firm and all the other agents are still straddling the wall. Designated is a form of dual agency. I can't do designated if I don't first have informed written consent to do dual. If they say no to dual, designated is not an option. I got to get a yes to dual before I can get a yes to designated. This only applies to in-house transactions. One firm, one transaction, two clients. Do y'all have that written down? One firm, one transaction, two clients. And either dual or designated, we have to have approval from both. We are getting to, I don't know if we'll get there today or not, but next week, we're going to talk about oral buyer agency. The seller has to agree to dual and designated before I can list their property. We got to have that agency agreement before I can do a single thing. Dual and designated is a part of that. We may be able to work with a buyer under an oral buyer agency agreement at first, but we got to reduce it to writing no later than the time we're ready to make our offer. We'll talk about oral buyer agency. I doubt we'll get there today. Once you've been designated, that individual, those individual agents will act exclusively for the principal of the side of the wall that they've been kicked off. So you're either exclusively working with the buyer or you are exclusively working for the seller. And the only way we can allow designated is if the firm has a policy in place allowing it. I know that's what's best for the buyer and seller. That may even be what's best for us, but the firm has to allow it. Y'all, please don't think designated is automatic because that's what sounds better. The firm has to allow it. It's not automatic. In order to be designated, again, we cannot have prior confidential information about the other party. And the number one problem topic, the provisional broker and the broker in charge cannot be designated opposite of each other. Do your head one way or another. Can the BIC and the PB be in dual? Can they be in dual? And I see lots of heads shaking yes, and I would agree with you. They can be in dual, they can't be designated. Why can't the BIC be designated opposite of their broker in charge? Because as a provisional broker, your BIC should be in your back pocket. Knowing what you're doing, know that you're going on an appointment today, knowing about your clients. They're assisting you through the transaction. They may even be with you at these appointments. So if they're doing their job and they're helping you, they know something about your client. It's because of the nature of the relationship between the BIC and the PB. You get in a listing appointment today, you call your BIC and you're like, oh my gosh, this is my first listing and they want me to come over tomorrow. What do I do? If your BIC wasn't going to be designated, you have to say, or she, good luck. But what do you want your BIC to say? Okay, this is what we need to do, and this is what we're going to handle it, and this is what you need to find out. No. They're involved in the transaction now, right? Because they're a good BIC assisting you, the provisional broker, through it. Again, you guys, some BICs have a policy that say they will never be designated. The Real Estate Commission doesn't care. Your test doesn't care about that. The only relationship not allowed to be designated is the broker in charge and the provisional broker. I want you guys to look with me. I need to edit your book a couple places because I don't want to, cause confusion this weekend. Please look with me first, page 162. Why don't you guys just go ahead and cross out situation 2? These are situations about how we can practice oral versus written, and we'll see this again next week. We'll talk about it, but if you guys are looking ahead, I don't want to cause confusion until we get there. So page 162, situation 2. And basically what situation 2 is saying is that if the seller has said if the seller has said no to dual in writing, because I can't perform a single service for the seller without getting that in writing. So the seller has said no. And then a buyer shows up and they have orally said yes. So the seller's in writing no, the buyer has orally said yes. We can go back to the seller and say, we have a buyer that's interested, but because you said no to dual, I can't show them the property. Are you willing to change your mind? Once it's in writing, it can only be changed in writing. And that's where situation 2 is misleading. So just cross it out. Once it's in writing, yay or nay in writing, it can only be changed in writing. So if we're going to get the seller to change their mind, we got to get that change in writing. The oral buyer can change their mind orally because it's not in writing yet. But once we have yay or nay in writing, the only way to change it is in writing. That's like basic contract law 101. So situation 2 is very misleading right there. Go ahead and cross that out. The other place, I want to edit your book real quick. Page 176. Number 2. I mean, if you want to look at it, just proceed, understanding. Once it's in writing, the only way to change it is in writing. So if the seller's in writing and the buyer's oral, only the buyer can change their mind orally. Do I have everybody? We'll get into oral buyer agency. I don't think we're going to see that today. If we do, it won't be for long. I've given you guys a lot to think about this weekend or week, whatever today is. Y'all please spend time with this. I'll show you in just a minute where you can get some other places to explain it. Yeah, I mean, you can disregard it, situation 2 and number 2. Or if you want to look at it, just know that that's what's wrong with it. Once it's in writing, the only way to change it is in writing. You now know something that your book doesn't. How's that make you feel? You're smarter than your book. One last type of agency relationship, we're just going to kind of briefly mention this and then move on, is rentals of property management. I got a whole unit dedicated to property management, so that's why we're just mentioning it briefly to move on. This type of agency relationship, the owner hires the property manager to manage their property. That's the whole job of the property manager. The property manager is an extension of the owner. The owner hires the property manager. So if you're going to be a property manager, the owner is your client. Very rarely is the tenant represented. Typically what we see, the landlord or the owner is your client, the tenant is your customer, which means the landlord or the owner gets old car, the customer gets honesty and fairness, and the disclosure material facts. This is or can be a struggle for property managers because the tenant is calling them. The tenant is having conversations with them. The tenant is paying them rent. And so the property manager needs to work maybe a little extra hard to differentiate that, to define that line. Who gets old car and who gets honesty, fairness, and disclosure material facts. Isn't it in your landlord client's best interest to collect rent every month? Absolutely. So when you're communicating and working with the tenant, you're doing it as an extension of the owner. You're doing it on their behalf. Because the tenant is very rarely represented, dual agency and property management usually don't happen that often. How many clients do I have to have in dual? How many clients in dual? 2. Always 2 clients, 1 firm, 1 transaction, 2 clients. Okay. Okay. Let's talk about our agency disclosure. I owe it to the consumer to let them know where I stand in this transaction. Do I represent somebody? Do I have somebody's best interest? Do I have somebody old car? And I owe it to them to let them know this before our conversation gets too deep, before they start sharing confidential information. Remember, I tell my client everything about my customer. I tell my customer nothing about my client. I don't owe you confidentiality until you hire me. So isn't it fair to let consumers know, stop talking, careful what you tell me, because I don't owe you confidentiality. Isn't that fair? If you were a consumer, wouldn't you want to know that? Everybody shake your head, yes, absolutely. So how we have that, those rules that we practice, is our agency disclosure. Agency disclosure is not an agency relationship. Agency disclosure does not create agency. Agency disclosure is my opportunity to say, you need to be careful what you tell me, because I already represent somebody in this transaction. My loyalty, my old car is to them. And what you share with me, I have a duty to tell them. I'm disclosing my status to the consumer. The whole point of our working with real estate agent disclosure is to let the consumer know, I don't owe you confidentiality until you decide to hire me. So what if you never hire me? I never owe you confidentiality. Guys, working with real estate agents is not a client form. We have already done this before you come my client. This is a consumer form. Maybe you're going to be my customer. Maybe you're going to be my client. Maybe I never, ever see you again. We're familiar one way or another with the Miranda rights. What in part do the Miranda rights say? Anything you say can be held against you. That's what I'm warning the consumer. I represent the seller in this transaction. That's my duty, my loyalty, my obligation. And anything you tell me, I got to take back to them. Again, information about the transaction. I don't care what you're having for lunch today. What is information that can affect us in this transaction. Working with real estate agent disclosure is required for all sales transactions. We do not have to do our working with real estate agent disclosure in lease transactions. This is a problem topic. You guys are going to see answer choices that say it's required in all lease transactions. You're going to see answer choice that's required in all real estate transactions. All transactions is sales and lease. I fear sometimes that if we're not going into property management, we tend not to care about property management. We don't want to think about property management. I got to get you through the tests. So whether or not you're going into property management or not, listen up. Real estate agent disclosure is required only in sales transactions when you are working with potential buyers and sellers. And let's be very clear. Is a commercial sales transaction a sales transaction? Yes. When we talk about sales, it could be residential, it could be commercial. You're working with buyers and sellers. So it's not required in lease, thus, it's not required all transactions. I have everybody so far. Just sales. We have a duty to give and review the working with real estate transaction no later than first substantial contact. I will talk about first substantial contact in just a second. Let's make sure we see give and review. We have to have a conversation with them about it. Don't just say, here's a disclosure, sign here. That's giving it to them. Did you review it with them? We have a duty not only to give them the disclosure, but also to review it with them. And we've got to do that no later than the time we've hit first substantial contact. First substantial contact is when I start learning information about the client and how it can affect them in this transaction. Once again, we can talk about the property all day long. But when I'm meeting a consumer and they start telling me why they want to buy, why they want to sell, what's acceptable price point, how high are they willing to go in their offer, how low are they willing to accept, any acceptable terms, do they have to close in a certain time? Once we start learning about the people as they relate to the transaction, we have hit first substantial contact. And by then, it's too late. Now, our goal should be to get this disclosure out before we hit first substantial contact. But I'm here to tell you guys that's not always possible. Because, and this blows my mind, people talk. They will come into your open house and they will say, I'm a very motivated buyer and I got to buy something, go into contract within the next 2 weeks. We've already hit first substantial contact and I don't even know your name yet. You guys with me? When you're acting in the capacity of an agent, you always need to be on alert for first substantial contact. So in a sense, we can say, please stop talking. You need to know that what you tell me, I got to share with my client. When you come into my open house, you know, I'm not going to bombard you with it when you come into my open house. Maybe we hit first substantial contact, maybe we don't. Maybe you come in my open house and you say, this is nice, thanks for allowing me to see it, have a nice day, and you leave. And I never see you again. We didn't hit first substantial contact. It's only when they start volunteering information about themselves as a part of this transaction, or I start asking questions. I cannot ask questions. I can't try to get information without first disclosing to them that it's not confidential. Does that make sense? Would that be honest and fair to treat the customer that way? So if I'm going to try to get some information from you, I first have a duty to tell you where I stand in this transaction. We keep all records, and this includes our working with real estate agents. We keep everything for 10 years, 3 years. Why did I just say 10? We keep everything for 3 years. I don't know why I said that. 3. Question comes in. What if it's a buyer, it's an oral agreement, refuses to sign an agency agreement? We will talk about that next week. So if we can, let's hold off on that next week. We'll talk about oral buyer agency. So all sales transactions, we keep everything for 3 years. That first substantial contact. This is the moment that we start learning about the person's price they're willing to offer, price they're willing to accept. When we learn about the person's terms, under what terms do you want to buy or sell your home? Or will we learn about the person's motives? Why do you want to buy? Why are you selling? We always need to be on alert for first substantial contact. If you're doing an open house, you're probably going to hit first substantial contact with somebody. If you're meeting a seller or a buyer for a listing appointment or a consultation, you're probably going to hit first substantial contact. Guys, this is the deal. There's not a rule that says there's ever too early to do our working with real estate agent. The rule says when it's too late. When is it too late? Once we've hit first substantial contact. In a perfect world, but guys, I'm telling you, people talk. I had a listing a couple years ago, and I think it was listed for 150, something like that. And my office, my firm, got a call on my listing. So my peer answered the phone and said, "Thanks for calling. How may I help you?" And this lady on the other end of the phone said, "I'm calling about 123 Main Street. I'm pre-approved for 150. I'm willing to offer 135. Can I ask you some questions on it?" Boom, first substantial contact. We didn't even know my girl's name yet. But we knew how much she was pre-approved for and how much she was willing to pay. People talk. It blows my mind. My peer said, "Whoa, whoa, 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 what are you doing?" And I get what she was doing. She was proving to us that she was a serious buyer. She was proving that she wasn't just out there kicking the tires. But did she possibly harm herself in that transaction? Because now when she makes an offer, I got to go to my seller and say, "This is how much she's a pre-approved for," right? I got to share that with my seller client. You guys with me? When you join your firm, they may encourage you to wear your name tag everywhere you go. Why do they want you to do that? Because people love to talk about real estate. So if you have your name tag on and you're in Harris Teeter looking at cereal, and somebody comes up to you in the cereal aisle and says, "Man, my husband's getting ready to relocate and we got to sell our house pretty quickly. Didn't first substantial contact just happen in the cereal aisle in Harris Teeter?" Anytime we're at, now I don't have those things in my purse. I do have them in my trunk, by the way, but I don't have them in my purse. Anytime that we're acting in the capacity of an agent, we need to be on alert. My husband calls me the traveling billboard. You want to know why he calls me that? If you ever get behind me in a stoplight, you'll know it's me. I have my firm, my name, the fact that I'm a real estate professional, my phone number, and my email address on the back windshield of my car. If I'm in my vehicle, do I need to be on alert for first substantial contact? Could somebody come up to me in the Walmart parking lot and say, "Ooh, you're in real estate"? You always need to be on alert. Most of the time, first substantial contact happens in person, face to face, at the open house, when you're getting ready to meet your seller for a listing appointment. There are cases that first substantial contact can happen by phone or electronically. Maybe you get an email. Maybe somebody sends you an inquiry on your website. If first substantial contact is not face-to-face, I still have to discuss it with them. Like my peer did when the lady told her how much she was pre-approved for and how much she was willing to offer. She said, "Please stop talking. I hate to interrupt you, but you need to understand that we represent the seller. You need to understand that we don't owe you confidentiality. And you know what that woman told my peer? You're the third listing office I've called. You're the first one that has explained this to me. Thank you very much. How many of you ever bought or sold a house in the last, I don't know, 10, 12 years? How many of you had working with real estate agent disclosure presented to you at first substantial contact? Let's see all those hands go down. Agents across the state don't practice this right. Your test is not going to ask you what they do. Your test is going to ask you what you should do, what you can do. Do I have everybody? This is the biggest place where your personal experience will let you get this test question wrong. Do not rely on your personal experience and working with agents when you answer these test questions. You got to focus on what the license, law, and commission rule says. We have a duty to provide it for substantial contact. Again, if you can't do it in person, we're still having a conversation about, I recently learned that young people don't know what this means. So we're still having a conversation about it. We're still discussing it. Maybe you're replying to their email and saying, please be careful what you tell me, da, 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 da. We still discuss it, but now we have a duty to get that form in their hands. I got 3 business days. What's your email? I need to send you this disclosure. We're still having the conversation. I want more time. That's what I want. But I want to, if we look at some things in the Unit 7 material, you guys, we'll talk a little bit more about this next week. This will be a good review. In the Unit 7 material, this is our working with real estate agent disclosure. We have a copy for the sellers or a version for the sellers. We have a version for the buyers. They both pretty much say the same thing. It's just one's to the seller and one's to the buyer, depending on who you're talking about. This form is required for use in all sales transactions. That includes residential and commercial. So if it's a sales transaction out the gate, the form's telling us we have to use it. Then the form says important. And the first thing this form says is, this is not a contract. I'm not using this form to create agency. Our agency agreement creates agency. This is not a contract. Signing the disclosure only means that you've received it. In a real estate transaction, it's important that you understand whether or not an agent represents you. Agents have a duty to review this form with you. We're going to give them a copy after they sign it. And then check out this 3rd bullet point. Do not share any confidential information with an agent or assume that the agent is acting on your behalf until you have entered into a written agency agreement to represent you. Otherwise, wow, the agent can share your confidential information with others. That's pretty clear, isn't it? Be careful what you tell me. Be careful what you share with me. Again, we'll talk a little bit more about this next week. This will be a good way to review and catch up since we'll have a whole week off. But y'all aren't taking the week off, right? You're not taking the whole week off. Y'all are good answers. Okay, so y'all are still going to study. So when we come back, we'll be able to catch up and review. I do want to show you one more thing I got in here for you guys. Another one of those Q&A brochures that the Real Estate Commission provides. We looked at condos and townhomes and subdivisions and streets. So now we got one on working with real estate agents. I think you guys should look at this weekend. This is a brochure that was written to the buyer and seller. This explains agency to the consumer. Back in my administrative days, I did new agent orientation. So I got you guys, as soon as you got your license and you affiliated with a firm. And the number one concern, the number one question I got from you guys as new agents is, how do I know what to say? When I'm meeting this buyer or seller, how the heck do I know what to say? And I'm a big believer that if you're familiar with the forms, let the forms put words in your mouth. Why y'all out there trying to recreate the wheel? Let the forms, be familiar with the forms. Let the forms help you know what to say. And this is a good opportunity, for example, for this Q&A brochure. All bold, don't you share anything confidential with me. And I like this too, because then it goes on to say, what does the word agency mean? This is us explaining to the consumer. What is an agency agreement? Is there a standard fee? And then there's a separate Q&A for sellers. We scroll down just a bit because it's 12:58. Here is a Q&A for buyers. So depending, we can use this form depending on who we're talking to. Are you possibly going to be a seller? Are you possibly going to be a buyer? We can use this form to help us have these conversations. This explains it to them. Y'all don't read it to them. Use it in your own words. Use it to help you formulate those words. But this is a great start. And then I think it ends with, yeah, termination of agency agreement. So I think you guys should look at the disclosure, look at the Q&A brochure, look at Unit 7, look at the rest of Unit 7. You know, we'll cover it. On Tuesday, we'll finish Unit 7, and then we get going into Unit 8. So please look ahead, both in the book and Learn, Test, Pass. If there's any questions, you guys, please don't hesitate to reach out to me. I hope you guys have a great week. Don't try to log on Thursday. I hope you guys have a great week. I'll see you guys a week from today, 9 a.m. We'll pick right back up.
Thank you. Have a good day.
Thank you.
Thank you. Thank you. Bye-bye.
Bye, everybody.
Thank you, Miss Julie.
Thank you. Have a good week.